and you have a copy of those in your packets.
I move we accept the minutes and letters.
Is your
Great. I move we accept the minutes and letter.
wrong one? Okay.
Watch Mr. Slade's mind come on.
Yeah, I know. I got mine coming on and off.
That was me.
I had it. Okay, there's been a motion and a second to approve the, Ms. Grimes, did you say meeting minutes and decision letters? Okay. There's been a motion and a second. All those in favor say aye.
Aye.
Are there any opposed? Okay, there are none. The motion carries. Okay, we will go ahead and move on to the first case on the agenda. If the applicants would like to move forward on the table, I'll read this introduction. This is the opening statement to the applicants. If you are not satisfied with a decision made by the Stormwater Management Committee, you may appeal the decision by filing for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the committee's decision. You are advised to seek the independent advice of legal counsel to ensure that your appeal is filed in a timely manner and that all procedural requirements have been satisfied. And the first three cases, which we are combining together, are 2016-00036. This is 2655 Miami Avenue, APN 052-090-15100. 2016-00037, and this is 2659 Miami Avenue, APN 052-090-15300. And 2016-00038, this is 2661 Miami Avenue, and APN is 052-090-15400. The inspector is Kimberly Hayes, and this is in Council District 15, being represented by Councilman Jeff Syracuse. The applicant's request. These are rehearings. All three cases were previously deferred on December 1st, 2016. On January 5th, 2017, a motion failed to approve the variance request. The appellant submitted written requests for rehearings, which were granted by the committee on March 2nd, 2017, with the rehearings to be held on April 6th, 2017. The original variance request for each case is to allow the following. 1, disturbance of the 50-foot Zone 1 of the 75-foot floodway buffer of the Cumberland River for construction of a single-family residence, including a porch, steps, and deck on the ends of the house. 2, disturbance of the floodway of the Cumberland River to construct cantilevered portions of the house over the floodway, maintaining minimum low chord of the structure approximately 6 feet above the 100-year flood elevation of 421.1 feet. The cantilevered portions will include 2 balconies and 1 living space area. 3, modified buffer signage with alternate wording as approved and placement as shown on the record plan, each property line at existing tree line. And 4, continuous mowing of the buffer to the edge of the existing tree line as shown on the record plan. The appellant is Precision Homes Incorporated, Mr. Gil Smith, being represented by Mr. Sean Henry and Mr. Walter Davidson. Comments. Previous staff comments, this was on December 1st, 2016. This area of Miami Avenue was substantially inundated during the May 2010 flood. And number 2, post-May 2010 flood, Metro purchased 11 properties adjacent to and within this same area, 1/3 mile, including an unfinished single-family residence previously owned by the appellant, parcel 152, and this was 2657 Miami Avenue. And we had a question at the time regarding the landscape mitigation plan. Did the applicant consider locating mitigation plantings near the existing tree line versus near the proposed residence? Previous staff comments on January the 5th, the same one about this area of Miami Avenue being substantially inundated, and then about the purchase of 11 properties adjacent to and within the same area. And then a third comment, the buffer regulations became effective September 1999. Mr. Smith purchased the lots on March 19, 2004. And then a fourth comment, Stormwater staff has evaluated the purchase or swap of Mr. Smith's property, and based on the asking price, $98,000 per vacant lot, $269,000 lot developed, It has been determined that there is no opportunity to purchase or swap the lots. The pre-2010 flood property assessor value was $70,200 per lot. The current property assessor value is $1,500 per lot. And the previous comment on March 2nd of 2017. In addition to the comments from January 5th, we had one additional comment. The appellant has provided a submittal for a request for rehearing. However, staff does not believe any, quote, new evidence has been submitted which could not reasonably be presented at the previous hearing, unquote, per Section F 1.1.6 of the Stormwater Management Manual. At the meeting, staff available to respond to the appellant's statement regarding, quote, incomplete and inaccurate information, unquote, and to the evidence submitted. The current staff comment is staff does not support buildings in Zone 1 buffer. Codes had no comment. Previous planning comments for December 1st and January 5th were deferred to stormwater staff. The previous planning comment on March 2nd, quote, planning will not have further comments for these cases. The previous comments from stormwater provide an effective premise for not granting a variance for any of the lots along Miami Avenue. Current planning comment was the same as March 2nd. Previous Greenways comment on December 1st of 2016. Shane Dennison and I visited the 3 residential sites on Miami Avenue yesterday and met with the engineer and developer. We agreed to not object to their variance request on the condition that they grant a Greenways conservation easement and show it on their drawings, install permanent signs that indicate that a greenway will be constructed in the future, and that they will install a crusher-run trail at the time the units are constructed, which Metro will later pave to meet our greenway standards for design. The previous comment for January 5th was the same as the December comment. For March 2nd, Greenway's comments remain unchanged from the revised comments we presented at the last meeting, and the current comment, no additional comments from Greenway's divisions. Public comments also that were presented, including some recent additional comments. This is from Council Member Jeff Syracuse. Paula, I cannot attend this meeting, but please record my alignment with neighbors and do not support this rehearing and variance. And all of these are related to the March 2nd request for rehearing. And then from Dorothea Hartley. I am so sick and tired of my flood bills to the tune of $200,000. I had flood insurance too. I own 6 properties on Miami Avenue, and that flood devastated my life and finances. I am almost retirement age, and this was my retirement plan. Now I am trying like hell to pay my debts. Unlike our current president, I do not believe in bankruptcy. Then the wonderful plan of Metro takes my value away on my property at 2667 Miami Avenue that I paid $50,000 for, and then tells me I cannot sell it as it has no value. They value it as $1,500. Thanks a lot, Nashville. Now I hear that they are changing their minds on all this. Does anyone know what they are doing out there? Does anyone care about the people, or is it the almighty buck that counts nowadays? Thanks for listening. From Michelle Vaughn Capps and Jimmy Capps of 2672 Miami. We own a house at 2672 Miami. We are concerned about the variance request on the riverside of Miami. We had understood that there wouldn't be any new homes built on the riverside because of the floodplain. We are also concerned about the possibility of too many weekly rentals on this quiet residential street. We have plans to move into our house permanently and worry about strangers coming in and out of the neighborhood on a nightly/weekly rental. Thanks for your consideration of the uniqueness of this neighborhood when making decisions affecting our wonderful Miami Avenue. And from Richard Lawler with the Pennington Bend Neighbors Association, this is, he's at 2313 Pennington Bend Road. Since our situation on Pennington Bend is similar to that on Miami, I would like to state my opposition to any relaxation of the requirements for building next to the floodway. Should one developer be granted an exemption, then as I'm sure you know, the following developers will want similar exemptions. And then from Carol Grace Anderson, she lists a P.O. box number in Nashville, Tennessee. I'm a property owner on Pennington Bend on the riverfront. I vote for the variances that are requested. I've been a taxpayer on our property for 25 years, and I feel that we should be granted variances if the buildings are built 4 or 5 feet above flood stage. I see no valid reason to refuse those variances. Thanks for listening. Have a great weekend. And then from Kim Sorensen of 2627 Miami Avenue. I have been notified that Gil Smith is requesting a rehearing regarding his wanting to build 3 houses on the riverside of Miami Avenue. This is in reference to case, and she lists the number 2016, number 36, 37, and 38. After the flood in 2010, the Miami and Pennington Bend neighbors were told that FEMA and Metro would no longer allow more building on the riverside. They said it was permanent. I'm hoping permanent doesn't really mean 7 years. The riverside properties were devalued and the property taxes were greatly reduced because they were no longer developable. At the time of the flood, Mr. Smith was in the progress of building a house on a 4th property that is next to these properties. The house flooded and he took the buyout. He got his full asking price even though the house was not completed, and now he wants to build 3 more next to that lot. I want to express my opposition to any more construction on the river, especially by Mr. Gill. I have lived across the street from 2 of Mr. Gill's other projects and have had to put up with heavy equipment in my driveway, fires burning all night with no supervision, trash piles that don't get cleaned up, repeated use of a backhoe slamming trash into a trash bin so hard that my entire house shook and I thought it would damage my foundation, and I think it did, and storing a backhoe in the neighborhood for 10 years. The construction of those houses took 2 years and sat uncompleted for a very long time until he finally finished them. I have heard him say he was going to build on the river lots and would keep fighting it until allowed to do so. I ask that Metro remain firm on their decision to not allow any more construction on the river. And then this is from Phil Claiborne. As the former councilman of District 15 during the 2010 flood event, I am very familiar with the Pennington Bend and Miami properties along the river. Based on that familiarity, I would suggest to you that almost all the lots in question are either in the floodway, the floodplain, or the buffer. Any attempt to construct a home with the required elevated height would be the structure completely out of character with existing homes, riverside homes that survived the flood and did not take the buyout. The city has spent millions of dollars since the 2010 flood to buy homes that were flooded along the river, and since that time, these vacant lots have created something of a park-like riverscape that greatly increases the aesthetic look of the area. It would be a travesty to allow construction in a clear zone again after all that has taken place to get the riverbank to the state it is currently in. I would urge you to deny the request to build on these sites. And then lastly, this is from let's see, where did I cut off this? Oh, Pamela Miller. I think I chopped off part of it. I am writing to express my opposition to the variance request, case number 2016-0036, for the following addresses on Miami Avenue, 2655, 59, and 61. A few weeks ago, the HOA Board of River Glen met with Trevor Hunt, the NRCS District Conservationist for Davidson County, to discuss erosion issues within our subdivision. During the course of that meeting, he mentioned that there were severe erosion issues on Miami Avenue that would have to be addressed in the future. Further, I was surprised to hear that Mr. Hunt considered the erosion issues on Miami more critical than those in our subdivision, which we feel are substantial and extremely costly to repair. Given the erosion problem as well as the history of flooding for this area, it makes no sense to allow a variance so that homes can be built at these addresses on Miami Avenue. It is my fear that the builder will saddle an unsuspecting buyer with a future erosion burden and be long gone before the truth is revealed. The average person holds a large portion of their wealth in their home. I believe the city has an obligation to protect buyers from builders that care only for making a buck and not whether the land the house is built upon is stable, sturdy, and free from known issues that will result in costly future work and loss of equity. And then I had these additional comments. This is from Jenny Seeley. I understand there's a rehearing set for April 6th regarding building on the 3 lots on Miami Avenue, Riverside. We are very opposed to building on these lots because they would have to sit so close to the street and because the future owners would have to park on the street. We have always maintained the beauty of this unique street by self-imposing a no parking on the street policy, which most everyone obeys with the exception of when we have company. Also, I thought he had taken the buyout after the flood on one of the lots there, as it had an almost finished house on it. Please consider very carefully what effect granting him permission to build on these lots would do to our neighborhood. Thank you. This is again from Kim Sorensen. Mr. Palco, I understand there is another hearing for Gil Smith in regards to his building 3 more houses in the floodway on Miami Avenue. If he is allowed to build on these lots, then this opens the door to many others who are watching Mr. Smith's case. You can expect several other builders to ask for the same permissions as Mr. Smith. I can think of about 10 other lots that are also in the floodway that contractors will be asking to build on. Mr. Smith already built on one of his properties and it flooded. He took the buyout, so it got torn down before it was even completed. I watched the last hearing, and I think the only argument for Mr. Smith is that he bought that property with the expectation of being able to build on it. I don't think that is proper reasoning to allow construction in this floodway. I'm against allowing more construction on the river floodway. After the 2010 flood, Metro made it very clear that there would be no more building on the river. And then this is again from Carol Grace Anderson. I won't be able to attend the meeting on April 6th, but as a property owner in the vicinity of Miami Avenue, Pennington Bend, I would like to give my full support to allowing variances on Miami Avenue at 2655, 59, and 61. As a property owner, I feel that we should be able to build or expand if it is reasonable and built above flood stage. Our property is our main asset and was a considerable investment. Thanks for understanding and adding this to the record. And then lastly, from Betty Blackwell, I have been advised that Steve Gill is asking for a permit to build 3 houses in the floodway. The agreement in the meeting our councilman and your office had with the residents in Pennington Bend was that no more houses would be allowed to be built in floodway properties. What has happened to that agreement? Many more stick houses are on the drawing board if this permit is granted. And at this time, I will turn it over to the applicants.
Ms. Key, thank you. Mr. Chairman, members of the committee, we're glad to be here in front of you this morning. Appreciate the recitation of the other dates in which this committee has considered the appeal applications in front of you. While I don't think that history is necessarily critical for your deliberation this morning, I nonetheless would want to make those prior hearings and those prior minutes a matter of the record for this case here today. Some of the letters that were just read actually were dated back for the March 2nd consideration. So I think, I don't know that it's really necessary at this point to dive into some of that. Maybe we'll hold that back, see if there's any opposition here today. I believe under your rules we have an opportunity for rebuttal. Is that correct, Mr. Chairman? Oh, okay. Well, then we'll address everything then in chief here. So what I have done is I've handed out to you a 2-page memorandum that is kind of outlining an outline of what our argument here today is. And what's really important, I think, is there's an impression, certainly from the letters that were just read, there's an impression that these properties are in the floodplain. And these properties and the homes to be built are not subject to flooding. Mr. Davidson has now demonstrated in the graphic board that's here, and we have a handout for you to take a look at. We've got 3 handouts and 3 boards, the same thing, just in lots for you to take a look at. But these properties are elevated above the 100-year floodplain. So going back to where Mr. Gill started with all of this, he started in 2016 before he filed with the Metro Water Services Stormwater Department. He filed an appeal with the Board of Zoning Appeals, was in this room, made a presentation demonstrating a hardship that exists due to the proximity of the floodway boundary, and as a result of that, the Metro Board of Zoning Appeals granted variances to allow a reduced size building envelope for the 3 homes to be built within. And importantly, the order from those 3 cases references the section of the zoning code dealing with variance criteria, and the board found emphatically, and this was a unanimous decision by that Board of Zoning Appeals, that building on these 3 lots in the reduced building envelope will result in no injury to neighboring property, no harm to the public welfare. So then the applications were filed and brought before you initially in December and January and March, and here we are in April. This board that's to my left, and excuse me for not introducing the team here, Mr. Gil Smith is on my right. He is the owner of the property under the business name Precision Homes, Inc. And, of course, Mr. Walter Davidson on my left, the engineer of record on this matter. I'm going to let Walter speak to his work product, but just in summation, what you can see by this graphic very quickly is that there's, and we may have to highlight it or something to draw your attention to it, but where that 100-year flood elevation rests, there's ground elevated above that. That's the existing condition. So the property presently is not subject to flooding for the 100-year event. And elevated above that, of course, is the home that we would be well elevated, not only above the 100-year floodplain. The finished floor elevation is not only 7.5 feet above the 100-year flood elevation of 421, but it's also about 2 feet above the 500-year flood elevation of 426. So the properties do not flood, and I know there's a lot of concern. There's an expressed concern about that, but we're not talking about a flooding condition here, a flooding situation. What we're talking about is solely the Zone 1 buffer and what can be done inside the Zone 1 buffer. Under your regulations in Volume 1, Appendix F, there are 4 criteria for you to consider in a request to alter or modify the buffer yard. And I'll touch on those very quickly. The buffer area shall be the minimum necessary, any modification shall be the minimum necessary to achieve a reasonable buildable area. Again, this was the reasonable buildable area has already been looked at by the Board of Zoning Appeals, but in terms of the modification that's being requested here, which is very minimal, and I think Mr. Davidson shows you that of about the 400 square feet of footprint, 92% of the address at 2655, 92% of the lot will be pervious. And he's got the other data, lot 2659, that's the lot number, address, 91% pervious, and the address at 2661 will remain right at 90% of the lot being pervious. So we submit that the buildable area that is proposed is the minimum necessary to achieve a buildable area, and that the slight reduction in this buffer area is the minimum necessary. Criteria number 2 is, where possible, any area equal to the encroached area or equivalent stormwater management practice shall be established elsewhere on the lot. That's being done in the form of a landscaping plan. Mr. Davidson has laid out on this drawing the amount of landscaping that he is proposing to be placed on the property. In addition, to the extent water can get under or be directed under the home, it's an unfinished storage area. It's pervious. It's allowed to have water seep into it. Finally, point number 3. This is your criteria. Variances for reducing the non-disturbance buffer require a written recommendation, positive or negative, from the Greenways Commission. You read the letter from Ms. Shane Dennison. She's present here today. The proposal here is to have a 12-foot proposed greenway across all 3 of the rear of these lots, and so we have that support. Finally, there's criteria number 4, which is really not applicable. It talks about intensely developed areas, which we are not in. So you can check the box on 3 of the 4 applicable criteria for modification of the buffer yard, and we submit that the documents in front of you and filed with the staff meet that criteria. The other aspect of your code, and I'll sum up here, but the other aspect is for you to consider is the minimum necessary buffer alteration, considering the flood hazard to afford the relief. Again, there's no flood hazard here. I can't say that enough. Frankly, when I was here a month ago and we asked for reconsideration, I thought we really had flood dangers. I mean, I wasn't fully aware until Mr. Davidson dove deeper into the data to learn that despite everything I've heard and read previously, we are not in a flood hazard situation here. Finally, your consideration of the request here today, the real question is whether or not the variance of the buffer yard is justified. And as you can see from this board, They're coming into, the home will cover about 17 feet or 35% of the buffer area. That's not the square footage footprint covering the buffer area, but just on a single plane, we're talking about 17.5 feet of a 50-foot wide buffer zone, and that's about 35% of that buffer width. Again, not in square footage. So the exceptional hardship that would result if this variance is not granted is the inability to construct a home, period. That's the hardship. And we submit that that's an exceptional hardship. Thirdly, the variance will not result in increased flood heights. That's clearly demonstrated in the drawings in front of you. There will be no change in flooding conditions because these properties do not flood today. And then considerations of public safety or extraordinary public expense or creating a nuisance, those really are not in play here. You heard some letters read to you from a few of the property owners nearby. I think I think Ms. Hartley is the closest neighbor to the property. She actually operates a short-term rental property there. It's called the Purple Moon House, where they conduct songwriting exercises and people come and rent, and it's really a short-term rental, but it's a business operation in terms of what's being conducted on the property. They're not just staying there, they're actually performing and conducting and writing. And a couple of the other folks who've commented here are concerned about the obstruction of their views. That's the property at 2672. Mr. Lawler is the president of the Pennington Bend Neighborhood Association. Mr. Lawler received a variance. Mr. Lawler's house would not be there but for the variance that this committee granted him to allow him to build there. And secondly, I understand he opposes the Greenway. We're contributing to the Greenway. He opposes a Greenway, opposes public pedestrians in the vicinity of his home. You've got support for the variance demonstrated in the record. Ms. Sorensen I know very well. She's a friend of mine. She's asked me on a couple occasions. We certainly do not have an attorney-client relationship, but she's asked me about situations she's experienced over there, and I'm surprised, frankly, that she's lodged her opposition to this. And in terms of Ms. Seeley concerned about on-street parking, off-street parking is being provided by the site plan. So on-street parking is an enforcement issue that faces our entire city, no matter where you are, whether you're in Sylvan Park or Music Row or East Nashville, 12 South, you name it, on-street parking is not a consideration of this board, respectfully. So I'll turn over to Mr. Davidson, and I know you're going to pepper him with questions, technical questions, because that's what you do, but I wanted to summarize kind of where we've been, where we are, and why we believe the buffer variance is justified. Thank you, sir.
Before Mr. Davidson gets started, did we have anyone from the audience that wanted to speak either for or against the request? Okay. All right. Thank you, Mr. Davidson.
Okay, we have shown a typical section, and for the most part, the entire building area is above the 100-year flood. There's one corner of the 2655 that is 1/10 below the 100-year flood. The cantilevered portion is several feet above the 500-year flood and 7.5 feet above the 100-year flood. We are on a typical lot. We're providing free trees, 32 shrubs, and 28 flowering perennials in the landscaping. And for the small space we had, that's quite a bit of landscaping. All of Miami Avenue is within the Zone 2 buffer. And while we haven't measured them in detail, we believe some of the houses on the other side of the street are also encroaching in the Zone 2 buffer. There is a little bit of high ground here where the property splits and goes partly to the river and partly out to Miami Avenue. So there's very little flow distance that would be involved in water flowing across, being filtered by the buffer. The soil is pretty rocky, which limits the infiltration capacity of the buffer. The staff has asked for the landscaping to be moved out to the woods. We will do that if that's the committee's choice, but we believe it'd be better to keep it between the greenway and the house rather than putting it back into the woods. What? Yeah, you can.
Mr. Chairman, if I may, these are the same drawings on a reduced size for.
Okay, we would point out that there's 2 houses under construction further out Miami Avenue than we are. There's 16 homes that have been built or recently built along Wooddale and Miami Avenue. There's also new homes going in on Miami Avenue. This lot asks for the same buffer variances that we are requesting, and that is one of the gentlemen that's in opposition. And he was granted exactly the same variance that we're asking for. And there is a new home currently under construction, and the ground on that home is 7 feet lower than is our property. And his finished floor will be several feet lower. This is just a blow-up of the Miami Avenue area showing the same information. And the river actually comes up and runs behind the lots on the other side of Miami Avenue, well before he gets up to the Miami Avenue level.
Is that it?
Yep.
Mr. Chairman, I think that concludes. Obviously, Mr. Smith is here, and he knows better than either Walter or I about the conditions that he's experienced there since he's owned the property. So if there's any questions of the committee or of any other property in the area that you all would like to have more information on, he's certainly more than capable of answering those questions. So I didn't see if there was someone here in opposition. No? Okay. Thank you.
There we go. So is this a rehearing? I mean, what are we doing here?
This is a rehearing.
So we're starting just like it was brand new, or, okay.
Correct.
All right.
And I believe, if Rebecca wants to bring those up, we have a couple of things. One that you'll see on this, back to the first one, Rebecca, will be fine. You have this in your packet, too, and that first item that you see is what the Corps had provided regarding what was inundated with the March 1975 flood, that's the flood of record, and then the May 2010 flood, the previous flood of record, and then the May 2010 flood, which is the pink. And then you also have a handout, and we also gave one to the applicant of some information that Tom Palco had put together, and you'll see it on the screen that Rebecca is bringing up. There was some discussion about properties that have been purchased by Metro, vacant parcels, existing homes that are occupied. And so if you look in your packet, there was a spreadsheet, but this also summarizes the color coding of the particular properties. You'll find a packet that had that inundation, that's right, color-coded with sort of a pink, a bluish color, and maybe a gray. Okay.
All right, I guess we're going to open up for questions at this point. Questions and discussions. Dodd, go ahead, please.
Okay, let's try to start with what's most relevant. The parcels that you referred to that have received variances in the past, they're identified as this, one of them is identified as this red parcel at the bottom. Is that the one you're referring to? Okay. Excuse me. On this blow-up version, is that the one you're referring to?
No, that's just a new home under construction.
Okay, so where can you locate on the map where the parcels are that you were referring to that have received variances in the past that are similar to what you're requesting today?
And while he's doing that, I did a bit of research. This is all based on since the 2010 flood, just looking at all of the single-family homes that came for a variance in one form or another. There were 37 single-family related variances that were requested or submitted. 4 of these were on homes that had a buffer disturbance request on a vacant lot. 2 of these were within the 30-foot zone 1 of a stream buffer. And then there were only 2 that were along the Cumberland River that were within the 50-foot Zone 1 and 25-foot Zone 2 buffer. One of those was at 2301 Pennington Bend Road, and I believe that may have been a Lawler property. And then the other was, that was Cumberland River, and then the other was 2014-00010, and that was on Riverview Drive. That was further down the Cumberland River. So you've had 2 that have been on vacant lots along the Cumberland River. All the rest were either additions or demo rebuilds, that sort of thing.
That were approved variances?
Right, those 2.
Okay.
Were any disapproved? Were those the only 2?
Those were only 2.
Those were the only 2, and they were approved?
Okay.
And they are...
Is that also the ones you're referring to?
Yes.
Okay.
Well, one is, I think the 2301, the Lawler residence. The other is on off of River Road. That's further down west side of Nashville. Those are the only ones within the period of post-flood. I don't know about the other you're talking.
Do we know whether those lots were actually in the floodplain? Do we have any idea?
They were similar. Where you
Well,
had
I mean, they're saying this is not even in the floodplain. That's the difference. That's what I'm asking.
there is floodplain on that property, on those properties.
On the properties that were, the variances were
This one
granted.
They're on the ones that were granted.
did
and
have
also-
flood on the property, in the building area.
Okay. On the variances that were granted, where the buildings were being placed, was that in the floodplain? Do we know that?
Yes.
Yes.
Okay. All right. And this is not. Is that correct?
Correct.
Yeah, can you clarify how this is not? Because I can't get in my head. It appears that you don't have any buildable construction going on in the floodway, but there does appear to be that you have a footing of the building in the floodplain based upon that cross-section you showed earlier of the house, your typical cross-section of a house.
The footing,
I guess
we
what I'm
get
doing is
18 inches below grade.
Okay.
We would be excavating down below flooded elevation.
Maybe put that drawing back up there for us. Okay. How is that building not in the floodplain? That's what I can't understand.
There is a natural ridge coming through the property that by field survey tied to core datum is about a foot, gets up to about a foot and a half above the 100-year flood.
But isn't that the hump that you're talking about, not where you're building?
But this whole area,
That entire area is above the 100-year floodplain?
right,
Okay. And it is within the area that flooded during the 2010 flood?
correct.
Okay. So, and that's really what I'm trying to get at, is that when you were saying earlier that we were not in a floodplain, you were talking about the regulatory definition
Correct.
of a floodplain. Okay. So this site does flood during flood events above 100-year storm events.
Yes.
Okay.
Perhaps.
Rebecca, can you bring up the site plan for, I guess, 2655, either one of those?
It's a regulatory note.
Okay.
This one,
Perhaps.
floodplain actually does cut across one corner of the house, and this corner of the natural ground is 1/10 of a foot below the 100-year flood.
Okay.
And that's all the floodplain we have on all three houses.
Okay.
Can you bring up the other two, Rebecca?
Mr. Davidson or Walter, you mentioned that the river will cut behind the houses on Miami Avenue.
Correct.
There's a bypass channel behind there.
Right.
Is this property exposed to any flooding from that channel over?
No,
Okay. So you're saying there's high enough ground that it won't flood from the back forward?
right.
Okay. Thank you.
I have a couple questions again on this map. The one, stormwater appeal 2011-0004, is that the one we're hearing later today?
I'm sorry, that was back in 2011.
Okay, 2011, okay. Okay, I'm still 4 through, okay, and we granted, and that's the one we granted out of 2, okay. And the 3 new homes above that, were there any variances required for those?
I don't have any other on Pennington Bend. Since the flood, I'm sorry, there could have been.
I'm looking at the second page of the, yeah, you're looking at it right there. Yeah, it says 3 new homes.
Those 3 were rebuilds, and they were built back within the floodway itself. But the variance wasn't necessary because they tore the house down and built back.
Rebuilds with the same footprint.
After the flood, you could go back and rebuild a existing home in the floodway.
Without getting a variance, even though you're in the floodway?
And you all, that's allowed by FEMA, and you all also gave a sort of a blanket variance to allow that buffer's disturbance for that.
As long as the footprint didn't increase, the impervious area didn't increase.
And they have to meet floodplain regulations.
Mr. Chairman.
Because they're existing.
And that was a provision of the ordinance that was passed post-flood when the city council set about to prohibit new construction of residential properties in floodways. And as we considered that, and there was a request from a property owner on Pennington Bend that for personal reasons, I mean very personal, the lady's, I think her parents' ashes had been spread on the banks of the river behind their house. Their house was substantially damaged. And because FEMA, in a substantially damaged scenario, would have allowed you to build back on the existing footprint of the house, a clause was added to that ordinance that allowed that very scenario to take place. New residential in a floodway was still absolutely prohibited. But that was the basis for that clause being added to that ordinance because of a personal reason and because FEMA in their regulations would have allowed the reconstruction on the same footprint that was added to our ordinance. One other question I guess I have, if I may, are these properties shown in the floodplain in either or both the 2001 maps or the new effective maps?
Yes.
They are shown in the floodplain?
Yes.
Has there been any effort to remove those properties from the floodplain?
No.
As shown in those maps? So they are in the floodplain, be there a high spot or not. If an owner has not approached FEMA and submitted the necessary paperwork to request a letter of map change, then it is very much in the floodplain. So.
Yes, Don.
Okay, so kind of going by process of elimination here. The statement was made earlier that there is no flood hazard, but staff obviously has some objections to the variance proposal. How would you all define the flood hazard here?
It's strictly based on the fact that these maps are based on modeling based on the 100-year flood elevation. And that's what defines where the boundaries of the floodplain lie on a map. So the position of the staff, I guess, is that we routinely encounter people that that find themselves owning houses that they didn't realize were in the floodplain, or that in some cases have actually bought homes after the flood to find out after the fact that their homes had water in them, and these were things that were not revealed during the purchase process. So I guess we look at it from the perspective of the element of risk. Every house has risk. If you're significantly above the 100-year flood elevation, you have less risk than somebody that's built a house at or below that 100-year floodplain. And I guess we have a different perspective, having been through the 2010 flood and experienced what can happen to a neighborhood. While on one hand we say it's not in the floodplain, on the other hand we look at the map that's on the screen right now and see that some significant portion of that whole bend in the river is in the floodplain, and in fact was inundated by the flood in 2010, which, depending on where you are around the metro system, could have been anywhere from a 100 to 200 to 500 to a 1,000-year event. It's different in every basin depending on how much rain fell in those basins. But certainly it's a significant event, and it's worthy of note that in August of 2013, we had another event in the Madison area, not far from this area, that dropped some 7 to 8 inches of rain in about 5 hours, and that's considered somewhere between a 500 and a 1,000-year event. So lest we get stuck with saying if you're above, even inches above the 100-year flood, you have no flood risk. We've since had another significant event that flooded yet again another, scores of or as many as 100 houses in the Madison area, many of which we're in the process of buying to demolish right now. So it remains an issue for us as staff to try to take houses out of harm's way. Further, whether you believe in climate change or not, there have been issues. There have been events around the country over this last year. Just last year alone, beginning in March, when most of northern part of Louisiana flooded significantly, followed by 3 significant 500 to 1,000-year events in the Houston and surrounding areas in Texas in April, followed by a June flood in Oklahoma where 9 inches of rain fell on one morning, followed later in June where Greenbrier County, West Virginia, sustained 23 fatalities with 10 inches of rainfall, 7 inches of that were falling in 3 hours. Followed on June 30th in Las Vegas, where they had to do swift water rescues on the Strip. Followed a month later in Ellicott City, Maryland, where they received 8 inches of rain in 3 hours, with 4.5 inches of those rain in 1 hour. 2 fatalities and 120 swift water rescues. Followed a month, 2 weeks later, by the flooding in the southern part of Louisiana, where they got 25 inches of rain in 3 days. Followed 2 weeks later in San Antonio, where they got 9 to 11 inches of rain. Followed then by Hurricane Matthew, and I don't even have statistics on Hurricane Matthew. But these were events that all occurred over a 6 to 7 month time frame last year, many in the south and southern half of the United States. And these are staggering events happening on a routine basis. And so these remain to be, some of the reasons why we're concerned. Obviously, we regulate to the 100-year flood elevation here, and our regulations go to prohibition against construction in floodways, and then the restrictions about, construction in buffers and things like that. So we as staff would stop way short of saying that because you're even inches or a foot above the 100-year flood elevation that you have no flood risk.
Mr. Chairman, may we have an opportunity to comment on those comments? Let me just say first, your regulations are not based on the horizontal map. Okay, the horizontal floodplain map is not what you base your regulations on. Your regulations are based on base flood elevation, vertical elevations. Okay, so certainly within the horizontal flood plain, there's going to be exceptions. There's going to be ground that was missed by the model for the entire river because it's a modeling exercise. We're talking about fluctuations in vertical elevations and whether or not the property is below that base flood elevation or above that base flood elevation, and our property here is above it. So this committee certainly has the wherewithal to consider detailed engineering analysis of particular pieces of property. FEMA didn't do that. They modeled the entire river. So what we're submitting to you is the very role that you have, and the very reason that this committee sits here today is to consider very specific analysis of individual pieces of property. Thank you.
I would also point out that the FEMA maps are based on aerial run topography, and there are inaccuracies in aerial run topography. Our findings are based on field run topography. And both the Metro ordinance and the FEMA regulations make provisions for removing property from the floodplain that can be shown by competent engineering surveys to be above the flood elevation.
I guess from my perspective, I would have felt more comfortable if that had already been done by this point. So we can't speak for FEMA, and I agree with you and a lot of those. It is a compromise between a horizontal and a vertical regime on how we regulate that and look at that. But I would have felt more comfortable at this point had FEMA already weighed in and said, we accept your letter of map revisions is out. So, I mean, staff has said it's in the floodplain, and I know we're going back and forth with that a little bit, but I would have felt more comfortable if that had been happening, or if FEMA had weighed in on that at this point. That would have helped me out a little bit.
I'm not sure why we're getting into this debate over floodplain. I mean, there are probably plenty of areas that are mapped outside of floodplain where they're below the flood elevation. And so, I supported this variance before. I'm going to support it again. I'm going to make a motion to support this variance, and I'm going to make it based upon a couple of different, and I know Dodge started going through his list of questions, and I think that they've passed more or less that list of questions. They've laid out their rationale behind why they should be granted a variance. I think they meet all those reasons. And I think I feel even more emphatically about this because at the same meeting we disapproved this variance before, we approved one in almost exactly the same scenario. It was exactly the same scenario. And so there was no consistency there. I am a former council member of this district. I know at least 50% of the people that sent the letters in. They're very good people, a lot of songwriters, a lot of people that have lived in that area for a long time. I know some supported it, some did not. It's nice to be able to live in an area and have a park-like setting, which I think is what they're enjoying now. I understand that. But there are people that own property there that do have property rights. This parcel is above the flood elevation. It is clearly an encumbrance. The buffer is an encumbrance to the property, which normally does not allow them to build on without a variance. I think they've met those requirements, and so I support the variance, with an exception that, a condition that prior to building any house on here, that they must go to FEMA and they must do a letter of map revision indicating that this property is not in the floodplain. And that's my motion.
All right. Thank
Question on that from just an engineering, I don't remember. Will they grant a map revision just based on the fact it's above the 100-year elevation at that spot?
I would assume that they would. I've done it before.
Even if it becomes an island, they'll grant the.
Yeah, I think so.
Yeah, they can grant that. They'll have to show FEMA the area that's outside of the 100-year, and FEMA will approve that, and then in future revisions of the map, it would show up.
I mean, I believe in climate change. I do that. I mean, I started a nonprofit myself based upon that premise. But, we have regulations that we're supposed to adhere to and follow. And our regulatory elevation is a 100-year elevation. That may change over time, probably will, based upon what we'll probably have more extreme events like Roger had mentioned. But right now, that's sort of our benchmark. And so that's, again, the reason why I would support the variance. I supported it before. And I think that maybe it wasn't clear before. I don't think it really was, that maybe these lots were actually above the 100-year flood. So I don't remember that. That maybe helps me reinforce a little bit even more why this variance should be granted. Even if the variance is granted, and it doesn't necessarily mean he's going to build there, quite honestly. Maybe that just increases his values for the properties where he could convey them to a nonprofit. I know we asked him to look at that before. No nonprofit was wanting to purchase the property, but maybe if he gets approval here and he can prove that these are buildable lots, he can get an appraisal, and maybe it's worth his while to donate these properties. It's an option available to him. But just because a variance is granted does not necessarily mean he's going to build it. And I think he meets the conditions for the variance. I think this provides him further flexibility and options to do things in the future. I see no reason why we shouldn't grant it.
Just a quick clarification on your motion.
Sure.
You said with the condition that any approval on building on the lot must go to FEMA and obtain a LOMR to show. What do they need to show out of
A letter of map provision indicating that these parcels are above, or these buildable areas are above the 100-year flood.
Buildable areas, okay.
Right.
I was going to say the lot is in the floodplain.
No, yeah,
Okay.
obviously, yeah.
Mr. Chairman, we need a second. I think we need a second for the motion so we can start the discussion about the motion.
Thank you, sir. Do we have a second on the motion?
I'll give it a second.
Okay.
Thank you, Mr. Slade.
So I'll start some discussion now that we've got a motion and proper second. We've got two issues on the table, the floodplain regulations and the buffer regulations. So we haven't talked about the buffer regulations yet. The Zone 1 variance applies as well. So I'll kind of back up from both before and talk more broadly about what I think is metro policy here. And I think we're all appointed by the mayor. We are a quasi-judicial body that makes site-based judgments on Metro Council-approved policy. So if we step back and look at this area, we see Metro policy, to me, being applied in a very clear way that has not been applied in the areas where we have approved variances in the past. In this particular area, Metro is consistently acquiring properties along the riverfront that were developed, that were in the progress of being developed, and that had development potential. So clearly, Metro policy is focusing on discouraging development on these parcels. What makes this case challenging is we've got a site that's in a gray area on the flood side of the question, but we've got a clear Zone 1 delineation. It's rarely that we approve variances in Zone 1, so that doesn't make it a slam dunk in terms of an approval of a variance. And we have this very clear Metro policy intent of not encouraging and facilitating development in these areas. We also don't have the same type of density surrounding the riverfront property where we have granted variances in the past, like we did for the downtown parcel that was in the Zone 1. There were adjacent properties that were already there. That represents a Metro policy focus for that site of allowing more development in areas that we'd rather not develop, but this site clearly has a different kind of policy focus. For discussion purposes, I think this is a super critical vote for our board. We've got enormous development pressure in this county. Every one of our board decisions in this climate are going to have not only a legal precedent-setting impact, but they're going to have a development policy precedent-setting impact. I see two options. One is we could slow this down and not grant any variance and let them go to FEMA and see what FEMA says, which is the normal procedure. The second option is we could recognize Metro Council's approved regulatory policy that we not develop Zone 1 buffers or Zone 2 buffers without variances. And we recognize Metro's desired intent to discourage development on the riverfront parcels of this particular site and community and deny the variance. Since we have a motion on the table to grant the variance, I think we're going to have to focus on the latter question right now, at least for the purpose of this current motion. If the author of the motion would be willing to withdraw the motion and instead offer a motion of deferral to allow FEMA to address it according to the kind of normal due process, that might be an option.
Let me ask a question. I mean, I like the line of thought or the train of thought that you're going on, but you talked sort of about policies and and focusing on the last one. And I don't know if I could articulate exactly what you said, but I'll ask Roger, I'll ask staff this question. Do these parcels, as they stand today, are they eligible to be purchased in the Metro program on floodplain properties?
Those parcels could be purchased if there was sufficient dollars and there weren't higher priority properties in other places.
Okay. So,
and I say that because the 250 or so houses that we purchased after the flood were purchased with FEMA hazard mitigation grant funds. And the 13 houses that we're buying right now along Gibson Creek are also being purchased on hazard mitigation grant funds. The City Council this past year has included $5 million in the budget to allow those dollars to be used either as a match or as an outright purchase amount to purchase additional properties in floodplains. But we're typically, as a rule, and because of the flood, and there were a couple of instances where we did buy some vacant lots, but they were, I think the one in the case of along Pennington Bend, Miami Avenue area, and Tom deals with these way more than I do, were vacant parcels that were attached to a parcel with a structure that we were buying to tear down. So to just buy vacant parcels is not at the top of our priority list.
So what you're really saying is that this property would be sort of at the low end of the priority list if the funds were available, correct? So if these houses were built according to his plan, and they were built on the property, parts of the property that were certified above the flood elevation, and the houses were built 4 foot above the flood elevation, would those properties then themselves, as they were developed, then qualify for be purchased by Metro? Let's just pretend there's a house on that lot today. The building footprint's above the 100-year flood elevation, and the house is built per regulations at 4 foot above the 100-year flood elevation. Would Metro then look at purchasing that property?
Our criteria has been to establish whether or not it was substantially damaged by a flood event.
Right.
At a flood event, that
could be any flood event?
That would be biblical proportions.
Okay. It could be any flood event.
A flood event that caused more than 50% damage to the house.
I'm not an actual flood event.
Right.
Right. Not a proposed flood event, but an actual flood event.
Right.
Right. Okay. I think this sort of answers your question. I know there's policy there, but I think these properties are a little bit different. I think Metro could perhaps purchase these properties as they stand today, but they simply choose not to because they don't feel like they're a significant hazard.
Not without a house on them, certainly not. I mean, if I have the option of buying a house that's had multiple flood events, I'm going to buy the house.
Roger,
and not
if there's
the
a
vacant
house
lot.
on it and the house has the area, is built on an area above the 100-year flood, and the house is 4 feet above the 100-year flood, I don't think that, and there was not a flood hazard. I mean, there wasn't a flood that actually occurred. Let's say we had a 100-year event, the house didn't flood, there'd be no reason that you would actually acquire the house. Obviously, if there was a biblical event based upon climate change and things that we can't predict, or that we can't really regulate by based upon our constraints. Obviously, if there was a 1,000-year event and the house flooded and was significantly damaged, I guess Metro could come purchase it. But the fact is, there's a property owner here that has property. And I guess I'm a property rights person. I've always been that way. I was that way when I was in the council. And that's why this board is made up of a lot of individuals, okay? So I'm the property rights guy. Let's just say that. And so I see that you have an owner here that has a piece of property. He has the ability to build on it. He has to have, he needs a variance to do that. I don't see any reason why we should not grant his variance, and then that was my motion. I don't think it's out of the question that he be allowed to have a variance and then go to FEMA to have this certified above the 100-year flood elevation. But I would be, I don't think we can grant a preliminary variance that basically says, get it and come back. I don't want you to do something and just be kicking the can down the road. So, I mean, that's why I make that motion, but I'll certainly listen to any other discussion that can be held. But I think that the chair, the person to my left, Mr. Dodd, Commissioner Dodd, I think he's going through a very logical, scientific process. I think that's a very good thing for us to discuss. I think this is an important vote. I do believe that. And so it's worthy of a lot of discussion. But in my opinion, I think they've met their criteria.
Respond to the suggestion that we defer. I mean, it seems to me that typically when we defer, it's because there's some more analysis we need to do once we get that definitive answer. In this particular case, I just don't see how that analysis is going to help us. I mean, to me, it seems more like a procrastination, and given the history of this particular application, I just don't see how the deferral would help us. I agree. It's a good question to ask on whether or not we should do it consistent with the past. I don't think it would be consistent with the past because in the past, I believe there was more analysis we needed to do after getting that answer.
And I agree with that. As their attorney pointed out earlier, as a matter of record, they've been here twice, and the first time I put options on the table to help the applicant get a quick decision. He's been very patient. He's been very persistent. This has cost him a lot of money, and he deserves a quick answer. I think that the issue still, though, remains is, and this is what I love about Nashville, and this is what I love about this board, is that we all respect each other, and we can disagree without hating each other. And I don't think what my good friend, the engineer I highly respect, Roy, said, I don't think Roy is saying we should allow variance here to increase the liability to the taxpayer. I don't think he's saying we should allow a house to be built here so the taxpayers has to come in here and buy a higher value, easily at-risk flood damage property when it's the investor who decided to take on the risk and not the taxpayer. And if we're going to help the investor raise the risk to the taxpayer, I just don't think that's good policy. I don't think that's consistent with Davidson County's political culture to increase risk to the taxpayer and cost the taxpayers more money by adding value that's not there now, that we don't have to approve, that we're not obligated to approve. Metro Council stated years ago that these buffers have value, and we're going to regulate them, and we're not going to allow development of them unless a panel of the applicant's peers find that a variance is warranted. And if this were any other site, I would be looking for ways to help the investor recoup their investment. There were all kinds of red flags that preceded this investment. There are all kinds of red flags that are asking for not moving forward with this variance by virtue of all these parcels being purchased by virtue of the ordinance to ban development in floodways. This one is just too close to the risk, and I think we'd be making a major mistake by approving this variance. And that's my position.
Thank you, Doug.
And it might be a little helpful if everybody would kind of weigh in on this so we can kind of see where they are before we vote, because, we're establishing a record here for precedent. And I think everybody's opinions would help solidify what will eventually be a majority vote.
I'm going to say one more thing and I'll be done, because I'm just sort of responding to what Dot has said. And like you said, we can agree to disagree, and we're good friends and we always will be. This has nothing to do with our relationship. It just has to do with different philosophies and perhaps how we look at things. And in my experience, and I've been doing this a long time, and was even part of the process of having a lot of ordinances approved, the buffers are not placed in respect to flood hazard. The buffers really are a water quality thing. That's what they are. They're water quality. And so if someone comes here and they seek a variance into the buffer, as long as they offset that from a water quality perspective, that's really what the buffer is. We have regulations that are based upon 100-year flood elevations, and those are the things that we adhere to, and we've looked at that, and this is above the 100-year flood. So from a flood risk standard, that's my benchmark. This is just my benchmark, my personal benchmark. So the buffers are not placed there to prevent you from building. They're not. They're simply there for water quality. That's why they're there. That's always been my understanding. Maybe we can disagree about that, but I feel pretty strongly about that. So if he can come in here and he can provide water quality, he can offset that in some mechanism. That's why we ask for mitigation. Every time we have a buffer requirement, that's what we do. We're looking for mitigation. That's what we're looking for. Impervious surface, whatever. And so that I'm not going to probably say anything else. I think this is really good to have some other discussion, because I think you very clearly understand where Dot and I stand on this. And so I think that's it for me.
All right.
Thank you, Mr. Chairman.
Thank you, Roy. Make it quick.
Okay. I need to provide my colleague with an academic paper about how riparian trees, which are water-hungry trees, consume water quantity as well as clean water and filter water. For example, an oak tree on an upland will consume 109 gallons of water a day. So we actually get water removed from floods by riparian trees. That's been documented. A Zone 1 buffer is the last line of defense for a stream. It is a critical zone for keeping the banks stable, and it's a critical zone for being the last filtering water gets, and it's a critical zone for pulling the last bit of water out of a flood that makes flood peaks a little bit smaller. So I wouldn't be making this point as thoroughly as I am if it weren't such a highly vulnerable, high-risk area that Metro Council has identified as a high priority area, or it wouldn't be identified as a Zone 1 buffer. So, and I think I've said all I need to say.
All right, thank you, guys. I appreciate your input on this. This is a tough decision. It goes back and forth lots of ways, and we've heard it a couple times, so it is a big discussion point. One cut over to staff. Yes.
Because a part of the motion, I just want to address the filing of a letter of map change. And because I am the community official that signs any letter of map change request that goes to FEMA relative to properties being built either in the floodway or or built on fill. I see all the letters of map change as they're processed by FEMA and come back to Metro, because we're the keepers of those documents. And in the interest of not kicking the can down the road with this, I occasionally see requests by citizens to have their structures, their homes, removed from the floodplain by virtue of the elevation. And you survey around a house and you establish the lowest adjacent grade. If it's above the base flood elevation, FEMA will send a determination document back that says what's removed from the special flood hazard area, the structure or the parcel. And in some cases, you can remove the house itself while the rest of the parcel remains in the floodplain. Those kinds of changes will never show up in a map modification because they're too tiny, they're too small. But that letter of map change serves as a documentation that the structure is removed. I've never seen a letter of map change come back from FEMA on an unimproved parcel where some component of that parcel is removed from the floodplain. And this could be the first time ever from my perspective. But I'm almost concerned that it's kind of unlikely that FEMA would say that they would declare some ridge across a property as being out of the floodplain while the rest of the parcel remains in the floodplain. And that would be the case here because significant, there is a ridge across the property and it's above the base flood elevation. So I don't know what you get. And so I say that because if this whole moving forward with this is based on getting a letter of map change process through FEMA, you could spend another 60 or 90 days and find yourself back in the exact same place we are today. They may or may not consider a request to remove a small piece of an unimproved lot. So
that gets to what my questions and concerns were earlier, whether or not that was feasible. And I think what we're hearing is that once you have a house there, they'll give you a letter of map provision to show that that house isn't in the floodplain, but that's all they're going to get. When the lot's empty like that, they're not going to be able to do that.
Yeah, you can define a boundary and get it removed. I've done it.
Okay, so before you build it, okay, so that's how they would do it. I just want to make sure it's possible before we put a condition on it.
It is possible. I don't want to make them come back for that. I don't want to kick this down the road anymore, but it is possible. That's just part of some of the information would have made me feel more comfortable about it. They could have that documentation from FEMA that said was. So I'm not saying we kick it down the road any further, but it is possible to remove certain areas. Ms. Grimes?
Yeah, so going back to not so much the floodway, but the buffer zone and Dodd's questions about the quality of it. So they're indicating mitigation on the zone, and is there a way for us to, is there some measure that they've done enough mitigation to really keep that buffer zone a high-quality bank improvement to address Dodd's issues? What would they have to do, and could they do enough to mitigate the concerns?
Look out to Walter here. Mr. Davidson.
Do you have photographs of the lots as they exist today? Do we have any of that?
I did not bring them. They've been here before. Right now, it's just grass lawn.
I just remember that from
Rebecca,
before.
they're in the
They're
application.
wide open.
I was speaking to Rebecca if she can find that.
Could you review your for the buffer disturbance? Just briefly review how you're providing water quality for these lots.
We are providing substantial landscaping.
Last file at the bottom, Rebecca.
Thank you, Paula.
Those
Davidson.
what the lots look like now. And we are not getting back into the woods of the lot. We're up there on the area that is mowed.
I just remember this. That's why I just want to everybody understand that you're not removing trees.
No trees
Right.
are being removed, and we're planting trees back on the lots, along with some shrubs that the landscape architect tells me are very water tolerant.
So for mitigation for the buffer
And the
disturbance.
staff comment have not been that we need more landscaping, less. It's just the issue of do we put it next to the house or do we put it across the greenway into the woods?
Okay. So for mitigation, you're maintaining that tree line and you're
Yes.
increasing the required landscaping on the sites.
Yes.
Okay. Ms. Grimes, does that kind of address your thoughts on buffer disturbance and mitigation?
Yeah, the fact that they're adding back to improve the quality of the lot. And right now, if it's just grass, obviously it's not absorbing the water or any of those things, but with additional trees and shrubs that are water tolerant and hopefully would absorb some of that water, would improve the lot versus reduce the value of the lot. As far as I'm not saying this very well. Doug,
No, you're saying it well. No, you're saying it very well. Can I add something to that?
Quick and small.
And I think the client deserves a thorough debate about this so that we have a good, solid decision. But and unfortunately, that takes time. But we have never, and I've argued for this, and this is probably an administrative procedures issue that needs to be addressed. And I think a Zone 1 decision like this probably warrants this kind of discussion. And unfortunately, it's not resolvable today. But we have never proven that the mitigation provides a metric for metric replacement. That they don't have any quantifiable evidence of that today. And I know from a scientific standpoint that it is impossible to put a building on that site and mitigate the water quality and the water quantity benefits of a riparian buffer metric for metric. It's impossible. And if they were to cover that house in vine and add vines and add a green roof and add rain barrels on every spout, put a pervious driveway in, put rain gardens on every corner, create 60% tree canopy on the lot, because I've actually calculated this and run the numbers, they'd still only do about 60% of what a native forest does. And Metro policy is moving towards a native riparian buffer on these sites. And I don't think we're setting a good precedent if we make it easy for someone to make that harder for Metro to do. I think that's what's at stake here, more than just giving someone a little bit of a chance to get FEMA to approve something that is surrounded by flood risk. So.
All right, thank you, Doug. Anna, I'm going to call on you and give you a chance to say anything before we call for a vote, if you'd like.
I think that I don't like that the area is prone to flooding, but they're going above and beyond, putting the house 7 feet above the 100-year floodplain, 2.5 feet above the 500-year flood elevation. I don't like building in the Zone 1 buffer. There's not much of a choice here. They're only disturbing 25 feet of the 50-foot buffer. All of Miami Avenue is already in the buffer. And I think they're providing significant landscaping mitigation. So I'm kind of the opinion that they're doing what they can with what they've got. They've made a good effort.
All right, thank you. Any other discussion?
Yeah, I'll go ahead and go. I think everybody on the board at least knows where I fall on this one, but I'll run through my thoughts and try to keep as succinct as possible. I agree, I think, with everybody on this board that we would rather this be Metro-owned property that's park. I think everybody thinks that. The people that can make that decision aren't at this table, and they've made that decision. So, I think our task, and there could be very good financial reasons for that decision, quite frankly, but our task is to grant a variance on a property that when you apply our stormwater regulations, it creates a hardship to build what's reasonably expected on that property. That's what our task is. And I see when you look at the letters, I agree this is a very critical vote. From the public, we had letters that are people, or at least one that was exactly in the same position, Mr. Smith. These decisions not only, they help both sides. One, you've got a group of people who own property that's going to lose value. It's not just Mr. Smith in that situation. There are other people in that same situation. Then you've got people opposed to the variance that, quite frankly, regardless of the reasons they put in their letter, their property gains value. They're just as biased when it comes to whether or not this thing gets granted. And then they had some safety concerns in some of those letters, which are valid safety concerns, but at the same time, I don't see any distinction between past variances. there are already existing homes on the riverside that we are continuing to build homes, as the map shows, throughout the area. And so I see a real inconsistency if we try to deny the variance just based on safety concerns. For two reasons, and I'll get into the other later. The difference between them, again, I think it's very significant that we're talking about buffer variances as opposed to something that's actually in the floodway. I've been on, this is halfway through my second term. I've not seen, and I'm not aware of, and I think based on Paula's research, ever denied a property from any development at all because of a buffer. Not aware of that ever occurring. So I think it would be completely inconsistent for us to make that decision today. There is a huge distinction between the floodway and denying development in a floodway. It has to do with safety. It's a federal policy, not just local. The buffers are for water quality. It is a different issue that we're talking about. And it does seem to me that regardless of the individual reasons people made decisions in the past, that the safety and this risk issue was huge, or at least a big portion of it. It certainly was the most significant portion of the discussion. And in my mind, we're talking about really whether or not the buffer should be, we should grant a variance to that buffer. And that's not a safety risk issue, generally speaking. At least that's not why it's there. It's there for water quality issues, which are valid reasons. But again, it seems that we continue to equate two totally different policy reasons into the same discussion. Every development increased risk in Nashville, whether you're on the top of the hill or not, because it's another person and house there that we have to serve. So every development, new home creates additional risk. It's how much. And there have been policy decisions made by Metro Council that 100-year floodplain is what they want to regulate towards. So any kind of personal thought that we should do more up and above that, it seems to me that's not our task. We should stick with what Metro has decided should be our deciding factors. And based on the 100-year analysis that's in front of us today, not just the old analysis, but the new analysis we've just recently gotten, we should grant this variance based on everything we've done in the past, at least while I've been involved with this board. So, thank you.
Thank you, Mr. Slade. Ms. Grimes?
I've been kind of waffling back and forth, really trying to decide which way I would vote on this. And because I think that the thought that Metro is moving in that direction to try to recapture the riverfront makes a lot of sense, and I would love to see that happen. But we can't hold up that flag when planning approved it, because that's a Metro committee as well. And if Metro's unwilling to buy it, as Lance said, that really puts what they're saying they want into play. And so for us to try to hold up the flag and fight the battle for them when they're not everybody's fighting the same battle, I guess just makes it hard for me to say that would be a reason to deny this when they certainly are doing the mitigation that's needed. They've met the criteria as outlined by their attorney and met the ordinances. So although I think it's a great goal, I don't know how we can be the one to stand in, to hold that line, I guess.
All right. Thank you, Ms. Grimes.
I guess I wanted to provide a little clarification. I think you mentioned planning approved it. They'd gotten a variance from the Board of Zoning Appeals for the front setback, but planning's comment was planning will not have further comments for these cases. The previous comments from Stormwater provide an effective premise for not granting a variance for any of these lots along Miami. So,
Ms. Secretary, can I ask for a point of clarification? These projects, will they be covered under a single-family stormwater permit if the variance is granted?
I might have to defer to Logan, but I believe they will just be regular building permits with stormwater sign-off.
For the greenway, do we have to do that under
For the building of the houses, if approved on these 3 lots, will it require a single-family residential permit or a Metro grading permit?
I think it depends on the greenway. If you're going to include the greenway in the development scheme, then I would think they would need a grading permit, but if not, then it would be handled under a single family.
Ms. Secretary, the reason I ask is, in the recent past, we had a property owner come before the committee who was unaware of a past variance condition on their site. In the event of a single-family permit, that might be something for the committee to consider, especially with some of these, like the unfinished storage space, how an eventual property owner might be aware of some of these conditions that would transcend the initial building of the property. If a grading permit, I don't think it would be an issue. If single-family residential, it might be.
I don't know how that's handled. Okay.
I'm unclear on does this go through our Tier 1, Tier 2, Tier 3 review?
Typically, with any property that has activity in the floodplain requires a grading permit.
Okay.
But there has been allowances with the single-family permit that they can go that route. And in past variances, they've gotten just a permit through Kimberly's office with single-family, so I'm not sure how that would be.
So Kimberly's looking at this when someone submits a single-family, I guess based upon this impervious surface, it decides on how much water quality you have to, what you choose to.
The infill requirements, I believe they're, I think, are they exempt? Because of the percentage of the developed area versus the entire lot, so they're exempt, since this is a long, narrow, they don't have to do infill requirements.
Is there a concern about that? Is that why you brought this up?
I think my concern would be that maybe an eventual property owner might inadvertently violate the conditions of the variance unknowingly. I think if they go through, obviously, the plan review section, the one-stop shop, it should get caught. So I think if someone is following that process, sometimes people do things unknowingly outside of that process that could be an issue. But I just wanted to raise that question. I don't think it speaks to the ultimate decision. I just, from an after-the-fact standpoint.
But is there something you feel like that we need to add in our condition if we were to grant this that would cover your concern? I guess that's my question.
They are required to do the elevation certificate. All that's verified as far as the floor elevations. I don't know if that elevated crawl space is tall enough to be converted to need a non-conversion agreement. I kind of doubt that, but I don't know.
There is the non-conversion document, and we are ready to execute that and record that with the deed to indicate that the lowest level would not be converted to living space.
And that's generally the process we like, that when a property changes hands, something has been recorded against the property so an eventual owner would know. So that would seemingly speak to that.
So is the applicant saying that they would fill out a form and record it? Is that what I understand?
Right. There is.
It's a form.
Metro has a standard.
Is that something you would be required to do?
Yes.
Okay. So it doesn't need to be added to this?
It's not a requirement, but you can make it a condition.
Well, let's add that. Can we do that?
Second.
Yeah, let's add that condition to this motion, that they be required to fill out this documentation and record it for each individual parcel, so that any future property owner would know, I guess through a title policy or title search, that there are certain things that they can or cannot do. So I'm requesting that to be added to the motion. I don't know if that has to be voted on.
Mr. Slade seconded it. All right, Paul, you ready to call for a vote?
Okay. All those in favor say aye.
Aye.
Okay. All those opposed say nay.
Nay.
Okay. The vote is tied. The motion fails.
Mr. Chairman, I would encourage you to take another motion so that we have a definitive decision by this board, not get hung up on votes. It's just a procedural irregularity that we don't want to judge remanding this back to you to do this again. So
let me ask legal account. Yeah, you can. I mean, like, if we have a tie vote, what does that mean?
A tie vote means that the variance is not granted.
Okay.
I see no harm in following the procedure Mr. Henry suggested. I don't think it's necessary, but I see no harm in if someone is willing to make a motion to disapprove.
Okay.
I don't think it's necessary. I think they have their answer. They've actually received that answer twice now. It's the same result, both hearings. I think they can appeal from a denial by virtue of a no vote rather than a yes vote on a disapprove. But, I'm fine with it either way, basically.
Yeah, no, I feel very legal's weighed in. From our legal standpoint, I think we're covered. Unless anyone else would like to make another vote to try again, I run another motion.
I'd like to ask the council, y'all worked very hard on this. Would it help you if we tied again on a denial vote as well? Does that help you?
No, sir. No, sir.
Okay.
No,
Okay.
what most due process requirements like to see when you get in a judicial setting is a definitive vote, whether it's a majority to disapprove or majority to approve. That's very clear, and there's no question about the decision of this board.
This just shows how important this vote is. And it probably also shows how well blended this body is. I just want to throw that out there. It's awesome.
Thank you. Addressing legal here. You weighed in. Is there any other chance, or do we need to clarify it any more?
Since this issue was raised before, I had looked into it before, I think in the first vote it was the same situation where there was a motion to approve the variance that was made, and that motion failed. In that case, jog my memory, Paula, was it actually by a slight majority they voted no? Is it like 4-3 or something like that? Or I can't remember whether it actually tied or whether there was like a one vote difference or something like that. And in this case, obviously, it actually tied. I think it's explicitly clear in Robert's Rules of Order that a tie vote is a failure for the motion to pass. So there's no variance granted. Without the variance granted, I think the property owner knows that he cannot proceed with the plans.
This was on from the decision, the meeting minutes and decision letter. This is on January 5th, 2017. Mr. Slade made a motion to approve. Mr. Roydell seconded the motion. Mr. Sevier and Mr. Dale voted in favor of the motion. Ms. Ronette Adams Taylor, Mr. Dodd Galbraith, and Ms. Deborah Grimes and Mr. Lance Wagner voted against the motion. The motion failed. So it was a majority that voted against the motion.
So I still think it's a very similar result. Actually, I was kind of researching that scenario for purposes of determining whether the rehearing was required on that basis, which was an argument that they were making at that time. And I did come across a case that arose out of a tie vote and did determine that that's an appealable result as well, I believe. So I do think that they do have their answer. I think probably if a motion to disapprove was made at this point, the vote would probably tie the same way. So I'm not sure if that makes any difference if we do that or not.
If I may, Mr. Chairman, what we're all looking for is, and what a judge would look for is, what was the basis of the decision? The standard of review is whether or not the decision for failure to get a majority vote here, was it arbitrary and capricious? Okay. So what the applicant deserves to know is, why is his application not being approved? What's the basis for not approving the application? The procedural glitch here is the way the voting's occurring, and it doesn't give the definition, the reason for why his application is being denied. So a motion to disapprove, if that were to get a majority, you state the basis for why it's being disapproved. That's really what we're looking for here, for the record.
I can speak to that a little bit as well. This potentially is a case where it's more likely that this will proceed on to further appellate review stages than some of the ones that we've dealt with in the past. Some of the general issues that we've discussed in this context, and I've sort of done a little reading up in the past month or two as this has been working its way through. The guidance that and let me say that they did, Mr. Henry absolutely correctly articulated the standards in our internal operating procedures for granting a variance from the buffer. And those provisions are not only in our internal operating procedures, but they're generally based on some provisions in the Code of Federal Regulations promulgated by FEMA. So, we didn't base that on nothing, and the thing that I think maybe wasn't clearly articulated is that there is certainly, maybe staff may be able to speak to this better than I can, but I think there's some general guidance from FEMA and probably other sources as well, that just because a variance process exists does not mean that a variance ever has to be granted. And that the criteria that were correctly cited are criteria that are required if you do grant a variance. You shall not grant a variance unless these conditions are present, that you have to have that exceptional hardship. It has to be the minimum possible intrusion and the other criteria that were recited. The exceptional hardship doctrine, I've come across a little bit more description of that, some FEMA discussion of the CFR provisions that's based on, and I think what we've discussed before is all applicable, that the financial reasons can never be a consideration. And they go further to say that it really is about the physical characteristics of the property, that the physical characteristics of the property should be unique, that they shouldn't be typical of other surrounding properties, and they should, that you should take into consideration that, once a structure based on a variance is built, that you're granting that variance for that structure for as long as it exists. So, if you're basing your hardship determination on some characteristic of the current property owner, that's a mistake, because property owners change and the structure will still be there. Other thoughts, there has been discussion about, in the past, in connection with this case and others, about whether failing to grant a variance would be an inverse condemnation. And I think I've gone on the record before as saying that I do disagree with that position, as long as the basis for the failure to grant the variance is the public health, safety, and welfare, the police power. I think that's also consistent with substantive due process, which does require, as Mr. Henry mentioned, that there be a rational basis for the Commission's decision that it not be arbitrary and capricious. And that does get into the consistency issue a little bit as well, because obviously, if there are two parcels side by side and all other things being equal, one is granted a variance and one is not, then there can be a shadow of arbitrary and capriciousness in the alternative decisions. Certainly, I do think it is helpful for the members, and you all have generally been careful about this, to articulate the rationales behind your votes. And we have heard from every member of the Commission. I think it would also be fine to expand upon the record, if any of the members of the Commission, want to further articulate the reasons for their vote. But other than having Ms. Ronette Adams-Taylor join and then hear it again en banc, I'm not sure how we could break the tie, I guess.
I don't mind expanding upon my reasons, if that would help when we go around. I am not. I have a hard time divorcing the flooding issue here because it is very prone to flooding, and I think more development out here will be a safety risk for first responders. I think it'll increase the risk for Metro to come out there and provide services out there in a flood scenario. And as I said before, it would have helped me if at least FEMA had weighed in above us and said, hey, we agree this area is outside the floodway and floodplain. Staff has weighed in and said they're not in complete agreement with it being outside the floodplain because of the FEMA map saying so. And I understand the elevations, and I've seen that. To me, the clarification on that would be to get FEMA to agree with that. And so that would have been, my standpoint would have been good to have that to fall back on. But right now, I see this as burdening the taxpayers and burdening the city with more development in the area that doesn't need to be developed due to the flood risks. And then the loss of the Zone 1 buffer is also a secondary concern of mine. So I think you've done a fairly good job of establishing how you would make up for that water quality loss. But I don't. It would be enough on its own for me, but with the flooding issues behind it, it pulls me to the no side.
I would just add, because this came up in the previous discussion on some of the public safety concerns, and this was news to me. I hadn't researched this to this degree of depth before, but the CFR provisions that our IOP provisions are based on actually do cite those criteria as well. A determination that the granting of the variance will not result in increased flood heights, additional threats to public safety, extraordinary public expense, create nuisances, cause fraud or victimization on the public, or conflict with existing local laws or ordinances.
Appreciate that. Thank you. Anyone else care to expand on their no votes? All right.
Mr. Chairman, if I may just finally, for the record, speculation and supposition about what might happen here in the future is not a reasonable basis to make your decision. If folks are voting against this because Metro may someday acquire the property for park space, that's certainly not relevant either. There's been no offer to purchase the vacant land as it is. No single offer to purchase these three lots under whatever program has existed or might exist. So you need to be aware of that. I'm not sure if you all were aware of that. Thank you.
All right. Thank you. Appreciate your work on the skies. Thank you.
Okay. Thank you very much. We'll get started with the next case in just a minute or two.
That's the best discussion we've ever had.
Yeah, that was a good discussion. It's painful discussion at times, but it's our job. It's our job.
I'm just happy we respect each other and we had a good debate. That's all right. The rest of it's determined by law and counting votes.
We can come to fisticuffs after the meeting's over with.
I'm going to go to D.C. and do that. So I'm not in D.C. That's
plenty of discussion.
Yeah, that's the record. If you're allowed to be for property rights, I'm allowed to be for water.
Absolutely. I got it. We understand that.
And we got a really fair hearing. I think we did over backers to try to help sort it out.
Yeah.
There's a lot to say.
Well.
Okay, we'll go ahead and get ready to get started with the second case. Okay. The next case, I don't know, were you all here when I read an opening statement to applicants? I don't know if you were at the beginning. Okay. Okay. The next case on the agenda is number 2017-00002. This is the Miles Property Industrial Site Improvements, and the addresses are 0 Murfreesboro Pike and 570 McGavick Pike. The APN numbers are 120-000-15400 and 134-000-01300. The inspector is Sean Herman, and the council district is number 13, Holly Hueso. The applicant's request. The variance request is to allow the following. 1, disturbance and encroachment of the floodway and 75-foot floodway buffer, 50-foot Zone 1 and 25-foot Zone 2 of Mill Creek for the construction of a portion of roadway widening and grading. 2, continuous mowing and maintenance of the entire disturbed buffer area. The appellant is Barge Cawthon and Associates Incorporated, being represented by Mr. Jeff Hooper. Comments. Stormwater staff. Stormwater staff has no additional comments and will defer to the committee. Codes had no comment provided. Planning will defer to stormwater for review. And Greenways comment is the Greenways Division requests a Greenways conservation easement along the Mill Creek frontage of the property. And Ms. Shane Dennison is also in attendance with Greenways if you have any questions. And at this time, I'll turn it over to the applicant if you just introduce the persons at the table.
My name is Dan Smola. I'm a project engineer with Barge Cawthon and Associates. I'm also a certified floodplain manager with the Association of State Floodplain Management. To my left is Louis Agnew, who is a general partner, one of the managing partners for Skyhawk Business Park, which is formerly known as Miles Industrial Property. And to my right is Mr. Jeff Hooper, one of another design engineers for the Skyhawk Business Park. In order to, first of all, I appreciate all your time this morning.
Can I interrupt you?
Absolutely.
Oh, I'm sorry.
I need to recuse myself.
I'm sorry, I forgot about that statement. Thank you very much.
Thank you, Ms. Maddox. First of all, I'd like to thank all of you for your time this morning. I'd also like to thank Water Services and the Parks Department for taking time out of their day to meet with us and coordinate and make sure that we've addressed their concerns up to this point. In order to properly understand the necessity for the appeal request this morning, we need to take a little bit of a step back in time to understand the site constraints that we're dealing with that led us to the decisions we've made to get to this point. On the site development plans that have been submitted, you may notice that the Skyhawk Business Park, approximately 80 acres, located just north of Mill Creek along the west side of McGavick Pike, is basically landlocked, with the exception of 2 access easements that have been granted access to McGavick Pike through MNAA property. In the past, for unknown reasons to us, McGavick Pike was constructed in such a location that it actually bisected a section of MNAA property, leaving the 80-acre parcel virtually landlocked with the exception of the access easements that were granted by the prior ownership group. Through early design planning, we had the opportunity to sit down and meet with MNAA officials to discuss the project because of its proximity to the airport to make sure that we addressed any possible concern they may have. At that time, it was indicated to us by MNAA that there is not only the easements that have been granted, but a runway protection zone that has been overlaid after the granting of those easements for one of the southerly runways on MNAA property. The runway protection zone that overlays both of the previously existing easements restricts any type of development within the runway protection zone. That includes access drives, sidewalks, building structures, anything that would have a human occupancy associated with it. MNAA strongly prohibits within that protection zone. For that reason, MNAA agreed to relocate our southerlymost access easement further south to remove it from the runway protection zone overlay that they have enacted in the last 10 years or so. The relocation of the southerly access point, which is the access point that you're seeing on our site development plans, is the only access point that provides us entry to our site development. Also, early in the design phase, we met with Metro Public Works to discuss the development and any potential improvements that may be necessary to McGavick Pike. Through coordination with the Public Works Department, it was determined that a traffic impact study would be necessary to fully understand those improvements to McGavick Pike. RPM Transportation Consultants was contacted to prepare the traffic impact study, and based on the results of their analysis, they determined that McGavick Pike would be required to have a left turn deceleration lane for all northbound traffic coming from the Harding Place intersection. So in order to properly access the site, we would have to improve McGavick Pike, which is today only 2 lanes through that section of roadway. That particular section of roadway that needs to be improved to provide the left turn lane is encumbered by floodway associated with Mill Creek through that area, some 2 feet below the base flood elevation. That section of roadway is also encumbered by the floodway and Zone 1 and Zone 2 buffers associated with that floodway. In order for us to provide the necessary left turn lane, the deceleration lane for northbound traffic to enter our site into the only feasible access easement that we have, McGavick Pike will need to be widened through that section. The widening of McGavick Pike will include the placement of fill material to actually widen the section, because that section of road is actually elevated compared to the adjacent Mill Creek. The widening will impact the floodway. It will impact the Zone 1 and Zone 2 buffers within the public right-of-way associated with that widening. We have provided calculations for the amount of material being offset for the expansion of McGavick Pike, and we have not only accounted for the floodplain offset on site of the proposed development, but we've provided 500 cubic yards of additional river and floodplain storage as a good faith attempt to try to improve what is already a flood situation in that area. In addition, in coordination with Water Services, we have picked out a place within the buffers on the site of the proposed development that is currently being utilized as a gravel driveway. It's compacted material. It's got some gravel overlay. We're actually going to remove that section of driveway within the existing buffers, and through coordination with the landscape architect, we've prepared a mitigation plan to replant and bring those areas back to their native state. So there will be improvement to parts of the buffer on site to help mitigate the impact of the buffers within the public right-of-way for the expansion of McGavick Pike. In addition, we've also met with the Parks Department, and we've provided them with some exhibits to grant a conservation easement along the southerly boundary of our site that will run the north side of Mill Creek along the entire length of the property. In addition, we've also given them conservation easement, or will give them conservation easement along the west side of the property to provide them pedestrian access along the south side of the property up to Bel Air Drive, which is the cul-de-sac to the left. This will provide them a link from Eazell Park from the south to Seven Oaks Park to the north without having to get the greenway through MNAA RPZ overlay area. So in conclusion, the appeal request is really to allow us to improve the public infrastructure of McGavick Pike, to allow us to widen, to add a single additional lane, to provide a left turn deceleration lane for people to safely access the proposed development. And it's also to continuously mow and maintain the side slopes within the public right-of-way for the expansion of McGavick Pike. In addition, RPM Transportation Consultants in their report also indicated the need for a safe sight distance triangle for northbound traffic. A portion of the north side of McGavick Pike will be maintained, mowed, cleared, and grubbed so that vehicles traveling northbound coming around the turn will have a safe sight distance while accessing the proposed development. We feel like we have been in regular communication with Water Services and the Parks Department, and at this point, I will welcome any questions that you may have.
All right, thank you, guys. Paul, is there anyone from the audience, or should I ask?
Do we have anyone in the audience that wants to speak for or against the project? Okay.
So just kind of to repeat and emphasize, I guess, the no flight path zone for the airport is what's forced you to push this down. So in other words, if that wasn't there, we could pull the driveway up and not be in the situation in the buffers.
Yes, sir, that is correct, which is also why MNAA was willing to relocate one of the access easements that had been previously granted further south to allow us access outside of their runway protection zone overlay.
Okay. And there's no possibility for getting the airport to readjust that overlay, or is there any possibility for the airport to consider that?
We've met with the airport on multiple occasions. The overlay is for airplanes approaching the runway from the south, and without any modifications to the runway itself, it is a set distance triangle associated with their use of that runway. There is a master plan of expansion that is supposed to take place as part of MNAA, so if anything, those RPZ zones to the north will continue to grow.
And those zones are set by FHA, not
FAA, yes, sir. Yes, sir.
Thank you.
Yes, sir.
All right. Appreciate it.
They have to be approved by, are they not approved by council? Someone has to grant them that property out of Nashville, right? The zoning overlay?
I don't know the answer to that. I'm sorry.
The RPZ is set by Federal Aviation Administration on the design. So let me back up. Is there a metro overlay, or we're talking about just the airport and FAA overlay?
It is an airport and FAA overlay. Now, the airport has, since we are within the vicinity of the airport, they have the ability to review and sign off on the building permit. So unless we can meet their stipulations and requirements, which includes no building or structure within the RPZ, they don't agree with the development.
So the overlay is not a metro overlay. It is
a MNAA and FAA requirement.
Yeah, but Metro had to have granted them the right to
The
sign off on
MNAA
the
does
permit.
have under the charter, or under, I can't remember if it's in the charter, if it's a private act that was incorporated into the charter, kind of exclusive authority over operations on its own property. So I don't know if that helps.
in Slade. There is an airport overlay district, and this property, which is a metro overlay, and this property falls within that. So that's why I'm saying metro. The airport has sign off on the building permit when any property is in that airport overlay.
So Metro has granted MNAA authority to deny the permits.
If it is in the if it's in the Metro Code, then that would be the Metro Council granting that. If it's in the charter, then that would ultimately stem from state authority.
The originate. But it's Metro. I guess my point is that Metro is the one that requires this. Just because it comes down from the feds, Metro has adopted that. Metro is the one that can tell them they can or can't build here, not the federal government.
The federal government puts a stipulation on the runway itself. It's the airport, and Metro's granted the airport the authority to it.
Metro's granted.
Yeah,
that's my point.
I just have a question of clarification. It's only the widening of McGavick that's in the buffer zone. It's not the access road to the property.
That is correct. Any disturbance on the site itself has been clear of the Zone 1 and Zone 2 buffers. We are not impacting the buffers on site at all. It is only within the improvement piece for McGavick Pike.
Is there a blow-up of that in your plans, or is it just it's the corner down here?
It's maybe the fourth or fifth sheet towards the back. It's 6.1 or 6.1, something like that, Rebecca. In that packet, in the folder, it'll say the full-size plans, sheets 7 through 14 or something like that. Yeah. Towards the end. That's it.
Yeah, 6.0, 6.1. Thank you.
Okay. Can we put the mitigation plan up there, drawings up there on the screen? Okay. Are you all also doing the mitigation design, Barge Cawthon? Okay.
No, Al Wilkinson Landscape Architects is providing the landscaping plan for
Do
the
you have a
mitigation.
representative of that firm here today?
No, sir.
Can you answer questions about it?
I can answer questions in regards to the placement of the mitigation piece and the areas available. I cannot answer questions as to the planting material that were chosen by the landscape architect.
Yeah, that's fine. Did you all conduct any kind of empirical analysis of the mitigation proposed for the site? You know, what kind of justification did you come up with to compensate for the loss of the buffer zones?
It's a good faith attempt to try and improve buffers adjacent to Mill Creek that today are not in a natural buffer state to help offset the impact from McGab Pike. On the south side of the property, you'll notice within that area there are some open spaces that we looked at improving to a greater extent. However, there are numerous easements that run through that buffer area that have ownership through NES as well as water services for sanitary sewer and sewer overflows in that area. We were able to pick an area where the existing driveway, the existing site access maneuvers down into the buffer area and then back up towards the site. We will remove the compacted gravel material that's been in place for that driveway access and bring it back to a natural state in order to help mitigate the impacts near McGavick.
So you don't really have an empirical analysis of like parameter for parameter kind of improvement. It's as you described, it's sort of a good faith, sort of a subjective approach. Okay.
Yes, sir.
So is there any way we can put any kind of overlay of the proposed access points over an aerial photograph? Is that possible? Is that possible? Are you that good? Okay.
Maybe we just put an aerial up there for a moment and kind of
like side by side, maybe kind of get the frames similar. I'm just trying to. I can read the contours, but it helped just to see kind of what the footprint of the buffers and
the overall grading and drainage sheet does show the site access point, and we do have highlighted the buffer improvement compared to the site access point. So if you're able to pull up the overall grading and drainage plan, that'll give you one spot to view all.
I'm gonna, if it's okay with the board, I'm gonna defer to one of my fellow board members to help me understand this visually. So.
I'm sorry, a deliberation should occur where it can be heard on the record.
This area here that I'm pointing out, that is the area to be improved for the buffer mitigation, and this is our point of access currently for the proposed development.
So this is Mill Creek. This is tributary of Mill Creek.
That's the road going to the side.
Gentlemen, I'm sorry, but I'll...
Is your mic on?
Okay. I'm sorry. Okay. Yeah. Okay. So you can hear us. We can hear us
You
conversing.
can't see what we're pointing at, though.
That's
That's
right.
that's the floodway buffers of Mill Creek.
Okay.
And this is their proposed mitigation. Their access drive is outside of the buffers. It's the widening that's not shown on this plan, was where they're encroaching into the Mill Creek buffer.
Okay. And that's why I'm confused. Can I see where the widening is that's encroaching on the buffers, please? Because that's what we're mitigating, right?
Yes.
Okay. That's why I'm not understanding what's going on here. Okay. So that, and where's Mill Creek there? So it's encroaching on a wide floodplain of, okay, Mill Creek is a wide floodplain.
All the road down here is in the...
Okay. Okay. You know, this goes back to what I was saying earlier about the role of mitigation. We don't know what we're getting from this with a good faith effort. and we need to have a better understanding of what we're getting. So in this kind of case, we typically rely on staff. And so I'll look at Michael since Roger's busy at the moment. But sorry, Roger.
I do agree that it is somewhat subjective. I know in having worked on several of these over the last few years, sometimes that subjectivity is good because it gives you latitude in working with the various projects and the various things that come into play from all sorts of parties, Metro, interest, like in this indirectly, MNAA and FAA. I guess the thing I would say is when you look at some mitigations, they are delayed, where you go into a bank or you go into some manner of activity that has to play out into the future. I think one benefit of the way in which we do things is the fact that we get it automatically in the same project. So I think there is some inherent benefit in that. In other words, you're instantaneously offsetting the impact or relatively at the same time. So I know personally I'm comfortable that any subjectivity is offset by the process that we have.
And
That's what I needed to know.
I can also just read you the language of the provision in the internal operating rules and regulations, which I think was cited earlier today, and which says, where possible, an area equal to the encroached area or equivalent stormwater management practices shall be established elsewhere on the lot or parcel in a way to maximize or provide equivalent stormwater quality enhancement and protection.
And I would just add, as we work with applicants from the very beginning when they're wanting to know what scope they're looking at, it's just a simple phrase. We point out equal or greater offset of the impact. And I think that's a good starting point. It is subjective, but it does give us a baseline to look at, and you end up with things such as what we see today.
Okay, so we've got no flood rise associated with this, right? Because it's on the edge of the floodplain, out of the floodway. So maybe we've lost a bit of flood storage with the embankment.
The calculations that have been provided, we're actually providing approximately 500 cubic yards of excess floodplain storage than what's available today. We're providing on-site cuts to offset that additional floodplain, so we're providing more than what's available today.
So that's based on a modeled flood rise?
That's based on the volume cross-sections that have been provided.
And that's sufficient for staff?
And I think you would be looking at what they're asking for a variance for. Anything other than that, it would be expected that they would get that approved during the plan review process per normal procedure.
Can you show me the plants real quick with the mics on? Okay. I'm sorry, I can't get my electronics to work. I didn't plan well ahead.
That's the mitigation plan.
I can't get my eyes to work now. What is that? Black gum?
Black gum, river birch, eastern red cedar, arrowwood, inkberry, and witch hazel.
Witch hazel. And Mike, y'all are happy with the vegetative mitigation choices as well?
Did the staff comments, Ms. Secretary, indicate any
There weren't
concerns?
any additional comments on the mitigation.
Well, obviously, per the process, we've worked with them. Rebecca, I think, has been involved with that. I don't know that she has spoken up with any general concerns. I think, obviously, our job is to make sure that some mitigation is proposed. If we feel it's inadequate, you will get that comment. Otherwise, we would just defer to the committee on what is submitted.
Our comments are usually just limited to as long as they divide the species having no more than 20% of the total and they use native species, and then we leave their level of mitigation up for you guys to decide on.
All right, and they've provided greater area, which fits the criteria.
From a LID and water quality perspective, we've also sized our level 2 bioretention areas from anywhere from 115 to 150% of the required volume in order to provide some additional treatment capacity as well.
Just for the benefit of my fellow commissioners, Barge Coughlin does an amazing job with bioretention designs, the best in town that I've seen. I just probably got in trouble with federal regulators over endorsing a firm's work, but I really admire their work. But it's our common practice that when someone comes in with a good reputation, that enhances trustworthiness. So just FYI. But there are other firms who are equally good as well who are not here today.
Okay. I see wetlands delineated on the site here. Have we been through the Corps and TDEC on any wetlands issues?
We've submitted to TDEC and we've been granted CGP approval, so we are covered under the current construction general permit with TDEC.
Okay. And you're not messing with that, and you're not messing with that wetlands. And we've looked for wetlands around the expansion of McGavick Pike, and I'm assuming there's not shown, but I want to ask a question. Are there any wetlands around there?
Not that we were impacting, no, sir. A hydraulic determination has been done, and there is no identified wetlands other than the pocket that's isolated within the buffer area that you're seeing.
Okay. Thank you. Yeah.
I move to approve.
Second the motion.
All right.
Would you like to state the reasons for approval?
There are some significant constraints that are primarily being dictated by airline safety. And the applicants made, I think, an excellent effort to try to avoid first, to mitigate where they couldn't avoid. They have a reputation of doing these kinds of projects well. Staff has not presented any objections. It's not ideal, but it's a good faith effort and I believe a solid technical effort. And for those reasons, I made the motion.
Okay. All right, there's been a motion and a second. All those in favor say aye.
Aye.
Any opposed? Okay, there are none. That motion carries.
Okay. Thank you, guys.
Okay. Oh, okay, we will go ahead and move on with the agenda. We've just been notified, I guess, that the council person is on the way for the case that's up at this point in time, and we wanted to see if you all would want to swap the two cases, the next to last case, and bring it forward. The applicant is here for that particular case, so we wanted to see if you all would be interested in doing that or not.
I'll make a motion to swap the two.
Second.
Okay, there's been a motion and a second. All those in favor say aye.
Aye.
Any opposed? Okay, there are none. That motion carries. Sorry, Mr. Jackson, I assume, do you have all your, the other, okay, I didn't know if you had any other professionals with you. Okay, thank you. If you want to make your way forward, I'll be with you in just a moment. Okay, your packets will be slightly out of order here. We'll move on to the last, well, before I move on, let me read this opening statement to the applicant. If you're not satisfied with a decision made by the Stormwater Management Committee, you may appeal the decision by filing for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the committee's decision. You're advised to seek the independent advice of legal counsel to ensure that your appeal is filed in a timely manner and that all procedural requirements have been satisfied. And this is the last case that is listed on the agenda. This is number 2017-00005. This is the proposed T-Mobile co-location, and the address is 105 West Webster Street. The APN is 051-080-00900, and the inspector is Catherine O'Hara. The council district is number 8, and it's Council Lady Nancy Van Rees. The applicant's request. The request is to allow disturbance and encroachment of the 75-foot floodway buffer, 50-foot Zone 1 and 25-foot Zone 2 of Gibson Creek for construction of an elevated utility platform with ice bridge, trenches for underground utilities, and installation of erosion prevention and sediment control measures. The appellant is Crown Castle USA, being represented by Mr. Scott Jackson. Comments. Stormwater staff. The landscape mitigation plan, drawing number L1, lists northern sea oats in the plant schedule. Please verify that it is a native species. Codes had no comment provided. Planning will defer to stormwater for review, and Greenways Division defers to Metro stormwater comments. And at this time, I'll turn it over to the applicant, and if you could just introduce everyone at the table. Thank you.
Thank you, Paula. Excuse me. I'm Scott Jackson, representing Crown Castle and T-Mobile in this matter, and I have with me our engineering team, David Stampy, who can answer some more technical questions than I can. This is about a co-location, as it's called in the industry, for a new install for T-Mobile to go on one of Crown Castle's existing tower sites, which was built in 1999, I believe. And we realized that the floodway buffer had expanded. This actually made it all the way through zoning and got approval and got to the grading, the building permit stage before we realized, we have to come through this part. And so I was pulled in at that point, and Paul has been great to guide us through this process of what we'd need to mitigate and make sure that we weren't going to be disruptive with allowing T-Mobile to go on.
If you could just give a kind of a brief overview of the project and what's proposed.
Oh, sure. This would be the installation of ground equipment from T-Mobile, which would be placed on a platform that we've designed, standing on piers. The site plan shows where the entire lease area that Crown Castle has is contained within the floodway buffer. There was no way for us to, expand because we didn't have any property rights outside of it, unfortunately. We have a fenced-in compound, and typically these carriers install inside that and lease space from Crown. In this case, they'll be leasing a footprint for which to build the platform and set the equipment on top of it, and then run their cables over to the tower and install their antennas on the top, obviously. And what we tried to do was figure and calculate the amount of of disturbance or fill that we were going to add with the pier legs, and then account for that in terms of mitigating through both grading and landscaping. And I may, if I have to lean on the engineer, the expert here, feel free for any questions.
And I believe we'd had some discussions with the applicant on this one, and they will meet all floodplain requirements for elevating their equipment and utilities within the floodplain. This is just strictly buffer disturbance.
So I'm assuming this is all open deck and metal, so do we ever calculate a volume of how much you're displacing, or is it?
Yes, to set the equipment on the piers, our structural engineer designed it would take 4 2.5-foot diameter piers to hold the equipment, and we based the calculation from existing grade to base flood, which was 446. We came up with the displacement for the piers would be a little over half a yard of concrete, and to displace that, the site actually kind of sits just, it waves a little bit, and we're leveling that out underneath the platform for 183 square foot to offset the fill, and then we had the landscape architect double the amount of total disturbance for the landscape mitigation.
Okay. And, excuse me, so mitigation for the buffer disturbance, I probably haven't got there in the packet. Could you just brief me on what the mitigation is going to be?
It was it Richie from Hodgson and Douglas went in, and we did roughly 500 square foot of mitigation, and even with the trenches for the utilities, we would be at about 220 disturbance. So we had him double it, and I think he proposed pawpaw trees and northern sea oats for the type of landscape. And what we'll do is the highlighted area that he has, they will go in there and remove all of the gravel, because the entire compound is an existing compact gravel. He's proposed for them to remove all of that, place in the planting material, and then do the plants inside that. And we were limited on where we could do our landscaping, because like Scott said, Crown Castle only has rights to that little diamond-shaped compound, so we couldn't go out and do it at the roadway or anything like that. We were stuck doing it inside the fenced compound.
With the chair's permission, may I ask a question? Hi, I'm Teresa Costonis. I'm with Metro Legal, and I advise the committee. I believe we've had a consistent policy in the past that the fee property owner has to sign off on a variance application. And it appeared from what I saw from Paula that Crown Castle only has an easement interest here. Who is the fee owner of this property?
The fee owner, and Teresa, I wish I could remember that name.
It should be on page C1 of the plan. Should have the property owner's name.
Mary Crossman, is that?
Yeah, Mary.
Yeah, that's it.
Has Mr. Crossman signed off on the application or expressed approval of it?
When I spoke with Mr. Jackson, because that was one issue that we came up, we said the property owner needed to sign, and he provided these documents, easement documents, and I thought you had something highlighted in there stating that Crown Castle was authorized to sign on behalf of them.
There is.
Power of attorney or something like that?
That's exactly right, Teresa. There is.
It's in the. I was almost sure something was in the documents you gave me.
It is. It's a perpetual easement that Crown got in order to be present at this property. They used to have a lease in place, like just a 30-year-long lease, and they went back a few years ago and did a perpetual easement with the landowner. And in a lot of cases, Crown will obtain the rights to represent the landowner's interests in hearings that come up as their power, kind of a power of an attorney.
So is the power of attorney within the easement document itself?
It is. Okay. It is, and I think it is paragraph 8. I can't remember.
One more.
While they're looking into that, fencing around that diamond portion, can you just give me a brief description of what was that, a chain link fence?
Yeah, it's existing 6-foot-high chain link fence.
Okay. Privacy fence with slats or just open?
It's just open.
It's open. Just open. Did y'all have any substantial damage in 2013 when Gibson Creek flooded on this tower system?
Crown Castle didn't make us aware of it. Everybody that is inside the compound right now is elevated to an elevation of 450.
Okay.
Utilities still run underground, right?
They are underground, yes, sir. Yes, Crown retains an easement from Webster Street up to a utility H-frame inside the compound that has all buried utilities to that H-frame, and then buried utilities from the H-frame to the existing carriers, and T-Mobile will do the same.
Yes, Roger.
Mr. Chairman, this is on Gibson Creek, and as you can see from the aerial photograph on the screen, that there is nothing left on that site.
Yeah.
The structures that were on that site were extensively damaged during that August of 2013 event in Madison. And most of those buildings were damaged or flooded and have subsequently been removed from the site. I'm not aware of damage to any of the facilities that we're in discussion about today during that event. A lot of those were very old, much older, predating flood. They're pre-firm structures. There was an old hotel that literally straddled the creek, and when the water came through the creek, it lifted it off its foundation and dropped it over in the middle of the parking lot. And so there was some interesting damage caused by that flood event. But again, this is an area that I think was constructed originally to protect it from events like that.
Was there any damage or any damage attributed to stuff backing up against the fence or backing up against this antenna?
Not that I'm aware of.
Thank you.
I will add this into the record. We did find in the easement documents in paragraph, section number 3 about easement area where they could sign for the variance.
Appointing them as the attorney in fact.
And that document is recorded, so if this property gets sold, it's searchable. I found that's in a good position. Okay. Any additional comments on this one from the board? Everybody's pretty quiet tonight. Tonight, sorry. Long meeting. Coffee's wearing off. Anybody care to make a motion?
I'll move to approve. They're removing a bunch of impervious area and putting in new plantings, and it looks like they're above the flood elevation.
Second the motion.
We do have the survivability clause in this, correct?
Yes.
I love pawpaw trees, but they don't stick around very well. You got hard to establish.
Right. Right.
So we have the 2-year survivability clause in there, so make sure it's aware of that.
Understood. And Crown is as well. Right.
All right, there's been a motion and a second. All those in favor say aye.
Aye.
Any opposed? Okay, there are none. That motion carries.
All right. Thank you all very much for your time and attention.
Thank you. Thank you, guys.
Thank you. And thank you so much, Paula, for all of the help. Nice.
Your last name again, I'm sorry. It's Tranter.
We'll get started in just a moment. I've got to organize a few things. Let's see. Did Mr. Dodd have to leave, or he's? Mr. Roy. Oh, I'm sorry.
But you can confuse me with Mr. Roy.
I'm looking directly at you.
Or Mr. Slade, or David Jackson, for that matter.
I'm sorry. Now, what did you say about Mr. Dale? He had to. He's gone. Okay. All right. I'm sorry. I thought maybe he just took a break.
He is here no more.
Okay.
He's left the building.
Okay, we will go ahead and get started with the last case on the agenda. This is number 2017-00004. And this is 5135 and 0 Hickory Hollow Parkway. The APN numbers are 163-000-07100 and 163-000-00700. The inspector is Kenneth Tranter, and the council district is number 32, represented by Council Lady Jacobia Dowell. The applicant's request: a notice of violation and stop work order, SR number 830338, was issued to the site on February 1st, 2017, with a $1,400 penalty for the following violations: 1, grading filling without permit; 2, inadequate erosion/sediment controls; 3, buffer disturbance; and 4, clearing of 12 plus or minus acres of property located in the floodway. Per the NOV, the following remediation is required to comply with Metro Code: 1, install EPSC around all interior streams; 2, schedule a hearing with the Stormwater Management Committee with a request to include buffer restoration plan approval; and 3, obtain any/all applicable state and/or federal permits. Following the NOV, the applicant is requesting a Stormwater Management Committee variance from the following items in sections 3.3 and 6.9 of the Stormwater Management Manual related to Metro Water Services-NPDS Office Enforcement. 1, Stormwater Management Committee approval of the Buffer Restoration Plan. 2, approval for the proposed work associated with the restoration plan within the floodway/floodplain/no disturb stream buffer. And 3, waiver of the requirement which requires a grading permit prior to disturbance within the floodway and buffer. Since being notified of these regulations, adequate erosion prevention and sediment control measures have been installed on the site, and these EPSC measures have minimized soil erosion and sedimentation and are preventing sediment from leaving the site. Consequently, the applicant believes no variance is needed from Section 2.7 at this time. The appellant is 5135 Hickory Hollow, LLC, being represented by Mr. Sam Parrish. Stormwater staff comments are as follows. 1, what was the purpose of the disturbance, and what was the rationale regarding proceeding without verification of A, whether or not any local, state, or federal permits were required, and B, the work is approved and would be compliant with current floodway, floodplain, and water quality buffer requirements and/or any other local ordinances. 2, please provide the name and contact information, name, address, phone number, and email address of the contractor that performed the work that is subject of the violation. 3, regarding the buffer restoration plan, which is Figure 7. A, the green crosshatched area is identified as a proposed seed and straw area of 4.75 acres, and the application narrative states that spreading a native herbaceous seed mix is proposed to diversify the plant community, create additional habitat for wildlife, and limit potential obstructions within the floodway. There was previously existing habitat prior to the disturbance. Staff recommends that if the variance is approved, a condition be added that the buffer restoration plan be modified to require planting of trees within this area. B, the plan states tree and shrub species will be planted randomly approximately 12 foot on center. If using seedlings, they should be on 6-foot centers. The following buffer restoration guidelines are provided by staff as an alternate to using seedlings. Vegetation should be planted using the following guidelines. Canopy trees, 44 trees per acre, 31.5-foot centers, minimum 2-inch caliper measured 6 inches above grade. Understory trees, 131 trees per acre, 18.3-foot centers, minimum 1-inch caliper per measured 6 inches above grade. Shrubs, 232 shrubs per acre, 13.7-foot centers, minimum 18-inch spread or height. Total plants, 407 plants per acre, 10.3-foot centers. The percentage of canopy trees, understory trees, and shrubs can vary by 10% as long as the total number of plants per acre equals 407. No one species should compose more than 20% of the total. The center spacing guidelines are averages and should vary throughout the buffer to obtain a natural appearance, not rows of vegetation. Smaller plants may be used, however, the planting density will need to be increased. A 4 to 6 inch high ring of mulch with a diameter between 2 to 3 feet should surround each plant. Mulch or mowing may be used to control vegetation for the first few years until the new plants are established. C, the plan states no species will comprise more than 1/3 of the total planted trees / shrubs. No one species should compose more than 20% of the total. D, mulch berms should not exceed 3 feet in height. 4, the applicant has submitted the following correspondence regarding TDEC and the Corps of Engineers. A 3/9/17 email in which the applicant sent a follow-up email to April Grippo with TDEC and provided her a copy of the variance application and restoration plan. The applicant stated to Ms. Grippo, quote, based on our conversation, it is my understanding that TDEC is not requiring a construction general permit for this site at this time because EPS measures have been installed and are currently preventing erosion and controlling the migration of sediment at the site. Additionally, no additional grading or excavation work is proposed, and we are only proposing to stabilize the site by mulching, replanting, and/or seeding disturbed areas. It is my understanding that TDEC will review and provide comments on the plan submitted to Metro, but is not requiring any additional submittals to TDEC at this time, unquote. B, 3/7/17 email in which the applicant provides a copy of a 2/20/17 response letter to John LeFew with TDEC stating, as per your letter of February 7, 2017, I am writing to advise you that no grading / excavation will occur without written authorization from the division. The only activities at the site, unless we obtain applicable permits, will be to correct the violations we have received, which measures are to install silt barriers, seed/straw to cover the ground, and bank stabilization material. All of these actions have been approved, reviewed, and inspected by Metro Stormwater as described below. And a copy of an email 2/14/17 email from Kenneth Tranter with Metro Water states, compliance has been achieved with regards to required EPSC installation. And also a copy of the original 2/7/17 letter from Mr. LeView on the subject notice of violation, complaint number 42-300, is also attached, which states, in order to begin bringing this site into compliance, you should submit a written response to this office describing the actions you have taken to correct the violations noted in this letter. C, a 3/7/17 email in which the applicant contacted Mark Carnes with the Corps to request meeting for a site visit. The applicant states, quote, at this time, we do not believe that federal permitting is required because it does not appear that any fill was placed in waters of the U.S. However, we are working to coordinate a site visit with them, unquote. Staff question, do any state/and/or federal compliance activities needed on the site reconcile with the remediation plan submitted as Stormwater Management Committee plan of record? 5, if the variance and buffer restoration plan are approved, staff requests that a condition be added that only minimal disturbance shall be allowed. Codes had no comment provided. Planning will defer to Stormwater for review, and Greenways Division requests a Greenways conservation easement along the Mill Creek frontage of the property. And at this time, I'll turn it over to the applicant, and if you could just introduce yourselves and the others at the table.
Excuse me, I'm Bill Farmer, and I'm representing the applicant. And to my right is Mr. Trainer. You've read the letter from him. He's with Metro Water. He'll address the issue of the sediment, the lack of sediment going into Mill Creek. We were retained by the applicant immediately after the NOV was issued. I'm advised that this property was purchased just to be held for a later investment. There are several properties that the members of the ownership of this property own throughout the Southeast and Tennessee, Middle Tennessee, and Florida, and they just buy them and hold them. The issue about the clearing is terrible, frankly. He contracted with a local person who then got a NNL construction company, and we'll get you their address in a minute, from Franklin, and told them that to clean the place up. Basically, it was an illicit dumping site. We've got photographs showing that. Scrub brushes everywhere, just a really unkempt piece of property. Was asked and was advised that no permit was needed. That's no excuse. That's no justification. He takes full responsibility as the owner of the property for what happened. So that's really not an issue here. Immediately upon getting the NOV, we were contacted. We hired what we believe to be the best natural sciences environmental firm in the region, BDY. And to my left is David Jackson, and to his left is Sam Pryor, who's going to be presenting the PowerPoint presentation. After this, if you have any questions, we're happy to answer them. We urge you to consider carefully the buffer program. Was really, I don't think we have any issues with the staff. Maybe the way that we're doing the restoration may conflict in some ways. There is an issue of cost, but there's also an issue of just what is the best protection for the environment. What's the best way to address what this property is going to look like after we do the remediation that we accept is required. David?
I'm David Jackson with BDY Environmental. Appreciate your time this morning. We're here mainly to answer questions. As Bill alluded, we're not here to dispute really anything in the NOV or our work with Metro Stormwater staff. We have presented a restoration plan in compliance with Metro's request, and if anything, that's one of the purposes of our appearance. There are some relatively minor issues that we would like to present and discuss to the board. Sam Parrish has done most of the work on this site, and he has a brief PowerPoint that I'll turn over to him.
Paula, did we want Ken to go ahead and present what had happened on the site first?
I think, and before we get started with that, I believe Mr. Roger Lindsay has some comments from the council lady regarding this. We'll take those comments from Mr. Lindsay, and then we'll get Mr. Tranter's comments, and then we'll move to the applicant. I'm sorry to change the order.
This is by email comment from Council Member Jacobia Dowell. It was an email sent this morning, April the 6th at 8:24 a.m., addressed to Tom Palco, and the subject is Mill Creek. Council lady says, "Hi, Tom. I am not going to be able to make it to the hearing today. I have a work-related conflict. I wanted to express my disappointment to the committee that this clearing was done with no consideration for our laws and the environment. Recently, the owner of the property next door to this one reached out to me. He was hoping to construct high-density luxury villas there and shared that it connects with this property that would provide plenty of free space. I knew this clearing was not accidental, and there is a plan outside of our laws. We already experienced flooding and water pooling in this area. I'm very concerned with impending development in Hickory Hollow Parkway and the intersection. The ditch line along Blue Hole is non-existent since it had not been maintained. I would like the plan to include replanting trees back in this area. I'm going to work on increasing the penalty for those who knowingly circumvent the law. Thanks, Councilwoman Jacobia Dowell."
And also, Mr. Tranter, before I get started, I did have one comment that came in from Carol Ashworth, It says, "I am writing you out of concern for the loss of this 12 acres of floodway and the loss of its associated natural resource benefits such as flood protection, habitat, and clean water and air. This type of event is happening too often in Nashville. My heart is breaking for the destruction and needless mismanagement of our beautiful city's resources. Please let this be yet another wake-up call to people who love nature and Nashville that we can do better. We must do more to improve our code of ordinances to protect and manage our natural resources, allocate the resources required to enforce them, increase awareness of these resources as valuable utilities to our city, and encourage people to report suspicious activities. I ask you to require a comprehensive restoration program be carried out at the developer's expense. It should extend a full ecological restoration of the area of impacted floodway. I also ask that you enforce the maximum fine allowed and that these fines be updated to reflect an amount equal to the lost. Thank you for the work that you do. Respectfully," and signed Carol Ashworth. And I'm sorry, Mr. Tranter, we'll turn it over to you.
Good morning.
And Paula, the council member is here. I wasn't sure if Mr. Honeycutt asked me to interrupt and see if there were any comments that should be added to the letter.
No, I think, there we go. I think my comments, are adequate and expressed what I wanted the committee to know. We're seeing a lot of development in our area, and we also know that it was only a few years ago that this area of the county experienced some of the most severe flooding. And we're still experiencing a lot of stormwater runoff and flooding, and we have not had a lot of respect for the environment around our community. This is just one occasion of people coming into our community and not really working with the codes and the ordinance we have set forth to protect the environment and to minimize stormwater runoff. I find it hard to believe, and as Ms. Ashworth said in the letter that she wrote, that these things are happening accidentally without knowledge and so forth. Most people who are in the business of clearing property know that there is a process to follow that includes working around environmental protection, stormwater, and with the city codes and ordinances. So I concur with her and agree that I would like to see a more comprehensive plan put in place for this area. Roy Dell, he's actually left the room, but Roy Dell is working on I saw his name on the engineering project adjacent to this and across the street. And so I found that very interesting that, he's aware of those two areas. And so with the development of those, it increased the likelihood for more water runoff. And so I do think we need to make sure that we are restoring it and being more respectful of the Mill Creek area and also the natural habitat that is around there, and putting the trees and everything back in place so we don't have more sediment going into our waterways. So that's my comments, and I thank you for the opportunity to come here and speak today.
Mr. Chairman, if I might, before Ken prepares to talk, just maybe set a little bit of background, maybe remind the committee of how, as it relates to grading permits, stormwater operates. At the current time, there are about 611 active grading permits in Metro Nashville. Our staff is charged with overseeing those permits to make sure they're being built per plan after they're approved. In addition to that, we have to allocate staffing resources, obviously, to investigate complaints where projects that would otherwise have required a grading permit do not have a grading permit. That is the case in this site today. Mr. Tranter is our inspector who is charged with going out and looking at those sites. When we considered the scope of the work done here, one of the things that we did was ask that the restoration plan come before this committee, partly because of the scope and partly because of thinking that that might be a better avenue than just a grading permit, given the likelihood of some work needing to happen in sensitive areas to execute the plan. So I just wanted to start with that information, and at this point thought it might be helpful for the committee to Mr. Tranter go over his timeline on the site, his involvement. He has inspected the site routinely since the disturbance, especially during rain events, to try to scope the or quantify the impact of the project. Ken?
Thank you, Michael.
Thank you. Just wanted to give a brief rundown of my involvement with the property. Again, I'm Ken Tranter, Metro Stormwater. the first page of the packet. There's an aerial view of the property, approximate locations. The red box is primarily cedar trees that were cleared on an area of high rock. Blue box is various hardwood. The yellow locations are where all the brush was piled up when the site was cleared. I received the complaint on the 30th of January and made a site visit on the 31st of January. Spoke to the contractor on site and shut them down. Did some further investigation of the property, who the property owner was, a contractor on site, so on and so forth. The notice of violation was issued on February 1st, and the stop work order was posted. Second page, some pictures of the initial site investigation, the land that was cleared, northwest edge of the property, the whole north side of the property. On page 3, there's 2 pictures attached. That's on the south side of the property, the area that was primarily cleared of cedar trees. The next page, page 4, is just a copy of the notice of violation that was issued to the property owner, a picture of the stop work order that was posted on site, letting anybody that went out there know that no additional work is to be performed on this site. On the 5th page, the 2 pictures are EPSC installation. There's required per the notice of violation. The first picture is silt fence that was installed over on the edge of Mill Creek where there's kind of a break in the berm. Next picture is up on the north side of the property. There's a tributary that runs out to Mill Creek, silt fence that was installed, and also biomatting on the banks of the little tributary. On page 6, the first picture is additional EPSC that was installed just on the banks of the tributary. This is further south and not really a potential for runoff, which is why you don't see any silt fence there. Next picture was seed and straw that was placed as an additional EPSC measure. Roughly 2 acres of seed and straw that was placed. This is on the northeast side of the property over by the tributary. On page 7, the first picture is up on the far north edge of the property where the tributary will run into Mill Creek, just seed and straw. The picture below it is additional seed and straw that was placed from the bank of Mill Creek over to the brush piles laid down the center of the property. Page 8 and 9 are pictures that were taken on the 4th of this month that just show, where we're at right now with the seed and straw placement, the grass growth, the EPSC that was installed. Based on my visits to the site, been out there numerous times, 15 site visits after rain events, and as far as I could tell, everything appears to be good. I didn't see any sediment leaving the site, entering Mill Creek. I have photographs of every site visit since then. Thank you.
Okay, sorry, Mr. Parrish. And we do have his PowerPoint in the folder, I believe.
Thank you guys for your time today, and appreciate you letting us do this short PowerPoint. A lot of these slides have probably more information than you need, so I'm going to try and, sort of get them in for the record, but not discuss everything in them, just to, everybody's time is valuable, and I understand that. So, but just wanted to go over a quick site history, which actually Mr. Tranter did pretty well, really well, kind of what the current site conditions are, talk a little bit about our proposed restoration plans, and then address some of the comments that we received from Metro and via Paula. So for that second slide, really the main points here, we understand that the property was in the floodway. The owner is an out-of-state entity. They purchased the property understanding that it had agricultural use and came and saw the property, realized that there was a significant amount of illicit dumping going on. The site is overgrown with invasive species throughout the understory, bush honeysuckle, privet, vinca, and really his main intention was just to clean it up, just to see what is this property, what does it look like, are there any potential uses for it. He contacted a local contractor, and that contractor advised him that to clean up the property there weren't any permits required, and being an out-of-state entity he just was not aware of the ordinance that Metro had on this. So per that next slide, N&L Construction is the contractor, and since the question was asked, I was just going to go ahead and read in their information. They're located at 113 Flintlock Drive in Franklin, Tennessee, at 37064. Contact name is Nathan Delvin, and the number is 615-578-3765. Not going to go over too much of this because Mr. Tranter did it. They did the clearing, not exactly what the owner wanted in terms of disturbing a full 9 acres of the property in the way that it was done. But as soon as Metro came out and stopped the work, he's done everything he can to work with Metro, install the proper erosion sediment control measures, get the site stabilized. So you go to that next slide, and basically all I wanted to show with this is just kind of the location. It's sort of a triangle here. You got Mill Creek on the west side, I-24 on the south. It's bordered by a railroad, and it's just a low area that sits in between it all. You've also got some things in the vicinity, Mill Creek Greenway, a local Antioch Elementary School there just on the other side of Mill Creek. So just wanted to kind of put that to give everybody context about where we were. Next slide just shows what it looked like when we went out and looked at it on the 31st. The seed has germinated. Stabilization is actually looking excellent. And so just wanted to show the committee that, just to show you, hey, we've done what we need to do, at least especially in the area around the confluence of Mill Creek and this tributary, to make sure that there weren't any sediment issues regarding Mill Creek. And, I think the main point here is we've been responsive with Metro. We've tried to fix the problem as best we can under the circumstances, and obviously we have to go in front of you to get our plan approved, but it is certainly our intention to get this site restored, stabilized. And I think the astonishing thing is, and I think this has to do with topography as well as the quick responsiveness of the owner and their contractor and installing the erosion and sediment control measures, is no sediment has impacted Mill Creek. There's been no documented turbid water or sediment running off into Mill Creek that would affect Mill Creek or its critters. So regular inspections are being conducted, and if you go to the next slide, the only thing that we weren't able to complete before getting the NOV is cleaning up some of this illicitly dumped material. That ranges from tires to trash cans to asphalt, shingles, brick, rock. It has a long history of illicit dumping. We've also addressed that by putting up the proper cabling and locking it, and we'll continue to maintain that to ensure no future dumping occurs. So the next slide is really the heart of it. It's the restoration planting plan. So we're just going to go over that and just make sure everyone understood exactly what we're proposing to do. I'll start here at the confluence of Mill Creek, and so here you've got a little red hatched area. That actually is an undisturbed area that we're proposing to do some invasive species removal, as well as some tree planting and stabilization just right at that confluence. I also think another important point before I go any further is everything that's in the white around there is actually areas that were undisturbed. So I think it's important to note there is a bank levee on Mill Creek. That was not disturbed, so that forested riparian area along Mill Creek remains intact, was not affected by our activities. Additionally, there's a forested area between the disturbed area and the railroad tracks that remains forested and is actually doing a great job filtering any runoff from the site. So as you move east, we've got this blue hatched area and the area in blue, or the area in purple, I'm sorry. So the area in purple just denotes the area of matting. What we want to do there is just go and spread sort of a wetland seed mix to make sure that, we get some proper plants established in there and get that thing started towards restoration. The blue hatching is actually a proposed tree planting area. It's about 2 acres. There we originally proposed 12-foot centers, and we're willing to consider other options on that. And so that'll all be replanted within 60 feet of the riparian area. We've also got these 2 little red hatched areas here, which are about, 1/10 of an acre apiece or so. And this additional yellow area, which is adjacent to sort of a low forested area. And we plan to replant trees throughout all those areas as well. The brown area is just the area that Mr. Tranter mentioned was dominated by cedars. It's got shallow bedrock. A lot of dumping and other rock has occurred in there, and that we're just proposing to do mulching and let some natural forest regeneration occur in there. And then, the biggest area here is this green hatched area, which we're proposing to do an herbaceous prairie. And we believe that is appropriate here because it's in the floodplain and it allows for a quick establishment of vegetation, as well as provides color and wildlife habitat and various other benefits, along with the adjacent forested areas, and just provides a sort of unique and different habitat than what was existing. Obviously, there was trees there, but the other issue is the understory was just a complete thicket of invasives, which includes the bush honeysuckle, privet, and vinca, which is going to be hard to deal with as we go back and restore this to keep that stuff from coming back in. So if you go to that next slide, I think the key component that we want to do first and foremost is get rid of the dumped waste and construction debris to ensure it doesn't go to Mill Creek. The other parts of this I've pretty much discussed. We are going to do the tree planting. We agree with Metro's comments. Based on our current proposal, no species will comprise more than 20% of the total. And I discussed the sedge meadow seed mix, so go to the next slide. And obviously, we've got some debris piles in the floodway and floodplain, and certainly it's our intention to move quickly to get those dealt with, and that includes mulching it, chipping up all those trees, which will provide mulch for the proposed sapling plantings. It's also suppress some of the weeds and invasive species. And with the 4.75 acre prairie area that we're proposing, we have chosen a high quality seed mix, and it includes sedges, grasses, wildflowers, such as milkweed, coneflower, sunflower, black-eyed Susan, various other beneficial flower and other species. And, we believe the advantages of this, include, based on some studies we've read in the regarding floodway management, a higher herbaceous plant coverage with a lower tree density can actually increase nutrient trapping as well as sediment trapping. So it can take up some more nitrogen, phosphorus, carbon, and that mixed with the adjacent forested areas we think is going to be important here. The other benefits is we can do it right now. And it provides that habitat diversity and an alternate food source for pollinators and other wildlife. And I think one other issue that's not on this slide is the placement of mulch. I think mulch is going to have to go where you're going to plant trees, and we're concerned, obviously, as well as Metro is, I think, about the amount of mulch that will be placed in the floodway. And the use of the seed and straw in the prairie will limit some of that mulch and the potential for that material to migrate into Mill Creek during any future flood events. So the next one is just a quick slide just showing the seed mix. Obviously, you can't read it, but just wanted to show some of the color and flowers and grasses that we're proposing. And then, the next slide just basically outlines our proposed erosion and sediment control details. Not going to go over that too much, but obviously it's our intent to stabilize it and make sure that no future sediment migration occurs, and we believe we've got a plan in place that will make that happen. In terms of response to the staff comments, we understand that they've asked for trees on 6-foot centers. to, replant the entire area to mimic what was there in terms of the forest. Looking at the adjacent areas, obviously, we think the prairie makes sense just because of the invasives and the potential for them to take back over everything. And that's why we've proposed that herbaceous prairie, but also we're concerned about the shading the riparian areas. And we think the tree planting that we're proposing will do that, which will aid water quality for waters going into Mill Creek. And we would propose to revise our plan based on NRCS's guidelines for riparian buffers, and would like to plant trees on 10-foot centers and shrubs on 8-foot centers, because that's sort of a standard, and that's what we've used also on the other stream mitigation projects that we've worked on that's been accepted by state and federal agencies. Also agree with staff comments regarding the use of mulch. I think that's really important just to make sure we control the invasive species and allow these trees and everything else to get a head start. So another one of the staff comments was just providing alternative planting plans and schedules regarding 2-inch caliper trees, 1-inch caliper trees with specific densities. It's on the next slide. And so I think the main point here is we did a cost estimate to see what these alternatives would cost, and the reality is you can see the numbers, but it's about a 2,400% cost increase to do the larger 2-inch and 1-inch caliper trees, and it's just really cost prohibitive. And for an area this large in the floodplain, the planting of seedlings with the prairie we think is the best option. So one of the other staff comments was, regarding state and federal compliance activities, and just the concept of making sure what we're proposing doesn't conflict with anything that state or federal agencies might require. And the answer is, no. We've consulted with TDEC, as you heard. They aren't requiring construction general permit at this time. We're stabilizing it. We're not proposing any additional grading activities. And we've also now had a meeting with the Corps of Engineers on the site. They didn't express any concern regarding what they saw. I mean, obviously, they didn't think the clearing was great, but, based on our proposed, plan to stabilize and no additional grading, they're okay with that at this time. And regarding the comment of the Greenways conservation easement along with the Mill Creek frontage, I think that's something that the landowners are willing to consider at this time, but obviously the details of that are a little unclear. You've got a sewer line, you've got an overbank levee, and we just don't know exactly what the footages they're asking for or what exactly that would entail. So I think that details of that could be worked out. And, the conclusions, the main issues are we just want to make this site right and restore the cleared area. And astonishingly, no sediment has impacted Mill Creek, and I think that is a testament to our close consultation with Metro, as well as the quick response installing the erosion sediment controls. And we think our herbaceous prairie and tree planting restores the floodway and improves the habitat and even the aesthetics. I mean, I think you've got some view shed, as was mentioned by the councilwoman, as well as from I-24. I think an open prairie with wildflowers and other things will not only benefit habitat and wildlife, but it'll also be aesthetically pleasing and bring some visibility to Mill Creek in that area. So that's all I've got. I'll sit, and we'd be happy to answer any questions, and appreciate y'all's time.
All right, thank you. I appreciate the overview. Paul, this is kind of new to us. Are we just up for discussion on the plan, or do we need to vote it into?
You will need to vote on approval. They have their variance request in there, approval of their plan that they've presented, approval of the work to actually do the plan.
Okay.
And I think it seems like there was a third item on there. Oh, and not to have the requirement for a grading permit.
All right, so let's open the floor for discussion here. Galbraith.
All right, I got a list of questions. I'll be quick and efficient. Well, I'll be efficient. I won't be quick. All right. So, our attorney, it's just a procedural question since we're so new to this. Are we required to hear NOVs because of Metro ordinance or because of internal procedure?
So there's a couple of different ways that can go. In general, you may hear on an NOV when the recipient of the NOV appeals the NOV.
Okay.
That those appeals come to this body.
So why
As
does
I
it come-
understand it, that is not this situation.
It's not this situation.
Right. That they are, correct me if I'm wrong, Paula.
With the NOV, that was one of their measures that were required to bring it into compliance was to go before the schedule a hearing with the committee.
Okay.
The NOV sheet, it actually outlines different things, and that's one of the items in this particular instance because of the buffer disturbance.
But certainly, since they're asking for variances, they would have to come before you for that regardless.
Okay, so the variance is what triggered it. Okay. All right, secondly, what kind of seed type was used to stabilize the site?
Right now, it's just in fescue.
Okay, that's an invasive species. Okay.
It's not ideal, but it was something.
Okay, but sediment's worse, so, but it's not ideal. Okay. So I think I saw from your photographs pictures of hardwoods around the edges that would have been similar to the hardwoods that were there. Is that a fair statement?
Correct.
Okay. How many tons of trash were removed?
I'm not sure how much were removed. There's still some out there, and what we proposed is to kind of stage and properly dispose of all
So
that.
we don't have any evidence of how significant that was. Do you have a letter from the Corps describing what you described a while ago? Any kind of written?
No,
okay.
sir, not at this
Okay, so that doesn't help us a lot. Were there any improvements to the tributary that flowed through there? Was it straightened, shaped? Was there anything done to that at all to make it look the way it does today? That was its kind of natural configuration without vegetation.
There's no evidence that they did anything.
Which included natives and invasives. All right. Would the prairie be allowed to reforest if it were to go from an early succession to a mature condition?
Yeah, I mean, we'd be willing to consider that. I mean, I guess our concern would be regarding the invasives. Our maintenance right now is just to kind of make sure that it remains stable, but we'd also be willing to, our thought was to maybe bush hog it every couple of years to help push down the invasives and help maintain that prairie.
Okay. So I'll preface what I'm going to ask staff with this. Every consulting firm who has decided to show up here today live, I've endorsed. So, David, you have a great firm. Really impressed with you. But I'll never do that again on another day. This was a one-time only kind of experience. Okay, so I think that takes care of all of our legal liability. All right, now, secondly, staff. Have we learned anything from what they proposed that would cause you all to want to change some of the parameters? And I'll preface my question with this. This should not have happened. Just because it's expensive to put back what needs to be put back is not a reason not to require the more expensive stuff to be put back. This is a big, so we need to make sure we get this right. So with that being said, and that's just my humble opinion, one board member, Michael, have we learned anything new from what they presented, and since everything's been presented, to stick with your all's original desire to plant the entire site, to go with higher caliber trees, to do all the things y'all have proposed, or are there any different thoughts on any of that?
I will say that they did come in earlier this week to speak to us after they did see our staff comments go out in the public notice. Some of the things, I guess, that concerned us was the placement of lots of mulch. That's sort of an unusual bio-loading to the stream, especially in a sensitive area like that. They did seem to be flexible in the placement of that, and I know Rebecca had worked up some minimal or maximum depths of mulch that would be allowable to try to reconcile stabilization, but not a lot of that biomatter being washed into the stream. Of course, in the floodway, that raises a lot of questions. I think for me, I like hearing about shading the riparian areas. And again, like you said, this is obviously not a good situation. Unfortunately for us, when we get involved, we're looking at, one, stopping the issue, which we did immediately. Ken had the gentleman get off of the machines and stop immediately. And then two, how do we best get it, as you mentioned, into succession going back to where it was? The big area where they're proposing the seed mix, we talked a lot about that when we met the other day. Understand where they're coming from. They brought up some historical prairie references of some professors that have looked at that. I think maybe there's an in-between where they could go back with this, but then we could have some ongoing efforts to flag trees that might emerge naturally in those areas and preserve those. Those type of trees usually flourish. That would be one option. Another option we threw out was maybe working with some NGOs or other entities that might be interested in doing some periodic tree planting in those areas. But I will say they did come in, they did work with us. I think we were obligated to have this come before you just because of the sheer magnitude of the fact they were going to have to be doing work that would require variance anyway to do this restoration work. So we felt like in an effort to get this most quickly resolved, get them on the way, and they did meet the deadline. They got onto the earliest committee hearing that they could, and I appreciate Paula working with us to help that happen. I think, where we find ourselves is just continuing to work with the site. I think we will need to be able to go, and we've committed Ken to going out, working closely with them to know exactly where they're going to disturb going forward, him inspecting and him knowing exactly, being able to reconcile what they are able to do and what they do. So I guess I don't know if that answers your question, but that's generally how we have looked at it and feel like this is a start.
And to add a little bit more to that, I reviewed the mitigation plan and submitted the comments on it. And our fear was that a property would be able to go in and clear a large swath of forest and not have to put forest back. So it's kind of a way to preemptively clear an area without getting a variance. And then they'll just be able to go and bush hog it every year, which just effectively moves that area of riparian forest permanently from the Mill Creek watershed.
And that's my concern is that we get back to really good stuff, and that we do extra to make up for the fact that we've lost older age material that was processing nutrients and carbon a lot more efficiently than small stuff can do initially. But we also want to get off on the right foot with the invasives, and so I'm a little concerned about just saying let staff and consultants figure it out, because I'm a little concerned that you guys need us to give you some cover to take this as far as it needs to go to get it done right. I'm a little bit at a loss to figure out how to word a motion, because I'd like to make the motion to kind of move this to closure.
You can put conditions on the grant of a variance.
Okay.
I might offer, there have been cases in the past where the committee has asked,
I think I got it figured out,
for annual reports on the progress being made on the site. That might be one option.
Okay. All right, why don't I state it like this then, and see if I state it in a way that helps or hurts what you just said. But I want to move that we grant the variances as presented with the conditions that this site have the capacity to return to a floodplain forest. And so what that should do is it sets as board policy that the end goal is a forest. And if staff determines that 1 and 2 inch cowper trees, after getting in discussion with the applicant and their consultants, is the best way to get to a forest faster and more efficiently, or there's a different mix of things could happen. Maybe creating an early successional forest is better than creating a meadow. I really don't think creating a meadow by itself is sufficient mitigation for what happened, even with the benefits of nutrient management and other factors. So, David, do you want to give us some input on that?
Thank you. Thank you, Mr. Chairman. Just a point of clarification on the meadow concept. It really came so much from what Sam has already mentioned, that if you go in and just replant it, it's going to quickly succeed back to a vinca, honeysuckle, privet thicket. And you will have the benefit in future years of the larger trees, because we lost some larger trees. We thought that for stabilization purposes, for the purposes of just creating a little diversity, in the Mill Creek floodplain, which, where it is undisturbed, this is fairly typical. You do have a lot of invasives. We thought for those reasons that this was a slight preference, frankly. The cost issue, the cost of the meadow versus the cost of planting seedlings on what centers, Sam? 10-foot, 8-foot centers. It's equivalent, Dodd. So we're not looking to save money on that. The 2-inch and 1-inch that we discussed with staff on Monday, that is a big number. But if we can just go in and do the bare root seedlings on that appropriate density, the cost isn't really a concern. And so my point of that is the meadow thing was just a way of creating something different in the Mill Creek Basin. And in terms of how it confers a benefit to water quality, I think there's probably some advantage, particularly with regard to sediment trapping, of having that herbaceous cover versus the largely kind of bare earth that you get under the honeysuckle and the privet. The nutrient issues, we haven't studied that. It's probably a wash. But I want to make clear that we're not looking for an easier way out. We're really just looking to see kind of how can we prevent this from coming back into honeysuckle and privet.
So I guess the only convenience would be the larger trees versus smaller trees.
That's correct.
Okay. All right. So, Mike, do y'all want to address that point specifically?
And I think it got a little lost in the comments, but we did allow for them to do a smaller tree on 6-foot centers, and that was guidance from Reggie Reeves when he did his riparian buffer Clean Waters from Urban Forest grant. So we would be amenable to smaller trees, but his recommendation was 6-foot centers due to the, we'll just say, spotty survivability of trees that size.
And one other thing that I'll note, in having seen some of these restoration sites in other areas similar to this, is right, wrong, or otherwise, it is incredibly hard to stake in a big tree that's going to encounter flood velocity waters. You end up with, they all look like that, which isn't the best case scenario. And I think in some ways, letting either seedlings or emergent trees take, they sort of like are a palm tree. They survive to the extent they can survive the floodwaters. And again, having seen a few sites, again, right, wrong, or otherwise, a bit concerned with coming in and trying to not let it just succeed naturally. I personally wouldn't want to just say it's going to always be a prairie. I think there's some middle ground where we could try to, over time, maybe just help it succeed as fast as possible back into a forested area. But that's my best professional judgment.
So let me see if I can restate a motion then that will accomplish all of this. To move to accept the variances as proposed with the following conditions: that staff work with the applicant in the goal of this eventually becoming a forested floodplain, and that could include some interim steps that don't involve creating a forest immediately, but that the applicant be responsible for that process, not nonprofits down the road, not volunteers down the road, the applicant. Okay, that's my motion.
I'd like to piggyback on that and say I would like to see a report on this, a yearly report. Something comes back to us, just updating us where it's at, just so we know that it is being taken care of and being reestablished. I'll throw my support back. The prairie concept, I think is kind of supported, but I'd rather see us go back to a forested area. For me, I almost see this as the community thinks it was cleared for a reason, and if they see a prairie, they will see that that reason was accomplished. And so I would prefer it, just for that political reason, to see it come back to a prairie. Back to a forest. From my point of view, I think it's better water quality-wise and better to see it go back to where it came from.
You said to see a yearly report?
I'm open for, even if it wants sooner than that, but just a kind of a yearly briefing on it.
And I need to address the easement issue because I just don't know if that's a fair or appropriate legal penalty for something like this. Is there a legal opinion on that? Can we even compel them to do that as a condition of the variance?
There is the issue of the waiver of the grading permit also.
I believe I talked with, Roger might remember, but I talked with Tom Palco, and I believe they are willing to waive that requirement for this particular instance here of this disturbance.
Yeah, and that's my motion. That's all three. That's the third variance, right? Yeah, okay.
Does that include staff working with the applicant? And I just want to address if there are any issues or concerns that come up, they would have to return to the committee, or your assumption is everything will be worked out with staff?
Well, my assumption is everything will be worked out with staff until they get to a point. Well, I just don't think it's good policy for us to be prescriptive as a board and to get into scientific details. At the state level, regulatory boards never hear NOVs except when they're appealed. So the really only reason we're having to do this was because it's triggered it triggered the need for a variance. I would like to keep this at the staff level, but the periodic reports will help us ensure we made a good decision, and that if we have a future situation like this, we may do something a little different or maybe a little more prescriptive. I just don't think we have the ability to effectively dictate details that professionals should be able to collaborate over.
Okay, so staff, MPDS staff,
I think generally what we will do is we'll simply go back to the applicant's professionals and ask them to fulfill the committee's decision and preference that area, that prairie area, go back to a forest, and then come up with a plan to do that.
Native, indigenous forest. Yeah.
And I would also ask, I'm not quite sure how we'll do this when we've done the multi-year plans before. We've had a property owner that we were sure they were staying put. Do we know that this owner is going to hold the land for a period of time that we'll be able to do the restoration during? Or will that then transfer to the new property
Their
owner?
current plans are were to buy and hold the property and then not develop it. They're not developers. To buy and hold it for an investment. Now, I've heard Commissioner Galbraith's discussion about not having NGOs or kind of a sort of a punitive issue for the violation of the NOV, and I understand the concern about that. But
no, it's not a punitive issue. I'm sorry to interrupt you. It's just a matter of if NGOs have to do the work that the applicant calls, that means other sites in Davidson County won't get those NGOs service and those donations unless work will get done elsewhere. That was my perspective.
Well, I understand that. I don't disagree with you. I'm just saying that if the costs get to the point that's prohibitive, they may choose to sell the property. I don't know that. What we hope to do here and continue to hope to do is work with the staff and our professionals and develop it in a way that makes sense and has some economic feasibility to it. And we recognize the wrong that has been done. There's no question about that. Ms. Kostonis can correct me if I'm wrong, but I think the NOV has its own punitive provision. It may not be adequate in this case, but that's what it is. And our intention is to continue to actually make the property better than it was. I think when you look at the visual aspects we're calling it a forest. It was a thicket of brambles and bush and everything else, and it was indigenous, but it wasn't, as I understand it, it wasn't as good for flood protection or runoff as the plan that they proposed with the prairie. Now, I get what you're saying about it, and I'm not a scientist. I don't know the answer to that, but putting it back like it was, the public shouldn't have reasonably expect a pristine forest, because that's not what it was. It was not a pristine forest. It was a trash dump with a bunch of briars and brambles in it. That's what it was. So whatever we do is going to be better than what it was. And to me, if the commission to fulfill the commission's duties under the statute, to protect the environment, to protect the sediment flow in the Mill Creek, and to protect the flood situation. I totally agree with you, Commissioner Galbraith. We need to let them work it out, and maybe that means tinkering with this prairie. I don't think anybody knows that for sure right now, but seeing how it goes. But at the end of the day, if the question is, are we going to hold this property forever? I don't know that, and the owner has to make a decision like any other owner would. Is what does it cost to go forward? And I understand that you shouldn't be worried about the cost if you did something like this, but and I agree with that. But the framework that we're within, I think we're doing the best we can to address it in a responsible way. These are responsible folks. He reasonably, or maybe not so reasonably, but he believed that there was no permit required based on a Tennessee resident telling him that. And they don't even, so that's the issue that we've got here. So I don't know whether they're going to sell it or not.
I have a thought in response to that, and in response to Ms. Doan's comment, if the committee's willing to hear it. If they had gotten a grading permit before this work has been done, then as part of the process, and staff can correct me if I say this wrong, but they would have had to file a declaration in a long-term maintenance plan and record that. And that would have been the assurance that future buyers would have followed those requirements. So I do think that we have in other situations required some kind of declaration of real covenants as a condition on a variance grant as well. So that might be an option here, because that would be sort of equivalent to what would have happened had there been a grading permit, and here they are asking for a waiver of the grading permit.
I'll go ahead and second Dodd's motion to officially get us into discussion of that motion. And I would like to add to that motion a provision that, I'm not sure the correct deal, something would get recorded so that if...
it could be equivalent to a declaration in a long-term maintenance plan, such as would be approved with a grading permit, perhaps.
Yeah, something very similar, so that if y'all do decide to sell the land, the next landowner purchaser knows this is part of the responsibility to kind of repair this.
I'll accept that friendly amendment.
Thank you. And I don't mean for that to be too punitive, but I do see that we've lost something, and whether or not the owner knew what he was doing and the contractor didn't know, both parties need to work that out, but one or both of them should have known, or should have at least known to call up Metro Stormwater and be like, what are the proper avenues? So try not to be too punitive and beat it down too much, but I do feel like we've lost something here, and need to, I think the community at large would like to see something put back, a good faith effort to put that back into that, to run with.
Yeah, and I don't know that it would need to be in perpetuity. Again, I defer to staff on this, but if at some point a forestation state is reached that's like back to what you all would consider equivalent to what it was before, then that could have a term that would end at that point.
That could also be recorded to the deed, which would override the initial.
It would be, what I was talking about was a declaration, just kind of like what we do with the grading permits and long-term maintenance plans.
And I do think it's a well thought out plan. It's very solid ecological restoration. Extremely solid ecological, good science. Just the diversity of the grass species and herbaceous species alone tells me y'all know what you're doing. Our concern is that on one hand, you've agreed that we have the flexibility for that meadow to turn into a forest on its own over time, which meadows do. And on the other hand, we've got this desire to try to at least establish what was there originally, and try to make up for what we've lost from mature trees. And that's not punitive. That's trying to take the metrics of what was there functionally and the metrics of what was there physically and try to replace it. And the message that sends is that, if you don't take the time to figure out that you need a permit, this is what it's going to cost you to do it. And so we've got an obligation to do that. And I also know just enough about our staff and David's firm to know that y'all are good collaborators, you're good scientists, you know how to work it out, and I'm confident that y'all will find a way to do it so that the applicant won't want to bolt and let the next person take care of it with this agreement that we've tacked onto it. So that's all my comments.
And with your, the other additional condition, was that a declarations? What are you looking for? What sort of?
Long-term maintenance plan.
Yeah.
I have declarations.
A long-term declaration of long-term maintenance agreement to be recorded with the property.
Okay.
And then one more for discussion so we can close this out quickly. The easement for greenways, I generally would support that. I think greenways needs to get in near Mill Creek as much as possible, but I'm open for discussion on that.
I don't think it's related to the impact, frankly. I think we have enough things built in for the function to function and physical to physical metrics. I think an easement normally is something that goes with development. Generally, development impacts in these situations. At least that's the way we voted fairly consistently. Mr. Slade, I'm looking at him for kind of consistency kind of thing. But so I don't think we need it in this case. I'm tempted to do it just because it's a very unfortunate situation that needs to be compensated. I just don't think that's the right compensation.
How was the complaint generated?
It came in from several sources. It came in from several folks. We started to get a flurry of calls where it is right on I-24. Several folks saw it, so we started to get, I think we got 2 or 3 different complaints and several others asking about it.
How would they, but then they wouldn't have known it wasn't permitted. I guess that's what kind of draws my inquiry.
I think the people who saw it found it very unusual that in that area with that creek that someone would be allowed to be doing that type of disturbance.
Generally, I mean, and I'll go ahead and in my opinion, the greenways easement would be appropriate. So I'll go ahead and make the motion to append the existing motion to add the greenways easement. I don't really see it as, I think this is an opportunity for Metro to get what they want in front of all their creeks. And I don't see any real distinction between there being development. I mean, if anything, I think the fact that they went out there and did what they weren't supposed to be doing in the first place would be more of a reason to provide it. And I don't think it, quite frankly, I don't think it hinders the property in any way. So I would make the motion to go ahead and add the easement requirement on the greenways.
From a parliamentary procedure standpoint, I think I can accept that as a friendly amendment so that we don't have to vote on the motion to amend, if that's okay.
Yes.
Okay, so out of respect for Mr. Slade, I'll accept that motion.
As another, okay.
As a friendly amendment.
I think the second has to accept it too.
I accept. Out of respect for Mr. Slade.
Okay.
I really don't want you to accept that or my respect.
You wouldn't want us to accept it because we didn't like you for sure, but okay.
Okay, are we ready?
I'd like to call for the question.
Okay. There's been a motion to amend to add the requirement for the greenway easement, and it's been seconded. All those in favor of the amendment signify by saying aye.
Aye. That'll work too.
Okay. And then as far as with the vote on the main motion with the amendment, all those in favor say aye.
Aye.
Are there any opposed? Okay. There are none. The motion carries. Okay, we will go ahead and move on to the business portion. We have nothing for this particular meeting. We will just, unless you have anything else, we'll just plan on meeting next month. Is there a motion to adjourn?
Move to adjourn.
Second? Second. All those in favor say aye.
Aye.
Motion carries and the meeting's adjourned. Thank you.
All right. Thank you, guys. Good discussions today.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.